Order. Without objection, the committee is authorized to declare a recess of the committee at any time. I now recognize myself for an opening statement. Welcome to everyone. As the first woman to chair the Committee on Oversight, I'm particularly proud to convene this hearing on what I believe is one of the most important things we can do to ensure equality for women in our country. Finally putting women in and the Equal Rights Amendment in the Constitution. Discrimination against women is a persistent problem, yet our country's fundamental document does not guarantee equality. That is why I've introduced the ERA 13 times during my career in Congress, and why I'm so committed to seeing this amendment adopted as part of our Constitution now. The Equal Rights Amendment was written more than 100 years ago by the legendary suffragist Alice Paul, who I'm proud to say was a relative of my late husband, Cliff Maloney. After decades of effort, the ERA finally passed the House in October 1971, 50 years ago this month, in a strong bipartisan vote. It passed the Senate overwhelmingly the following year. The preamble to the amendment included a 7-year time limit, and in 1979, Congress voted to extend the limit by another 3 years. By 1982, the ERA had been ratified by 35 of the necessary 38 states. Then momentum behind the amendment stalled, but that all changed in 2017 when the women's marches and the Me Too movement reminded us all that we are still a very long way from equality. In 2017, Nevada voted to ratify, Illinois followed in 2018, and Virginia in 2020. 38 state legislatures have voted to ratify the ERA, meeting the constitutional requirement. But the ERA still does not appear in the Constitution, and this has to change. Federal law directs the archivist of the U.S. to certify and publish amendments that have met the requirements laid out in Article 5 of the Constitution. This is purely ministerial duty, which should be done automatically. But under President Trump, the Department of Justice issued an opinion advising the archivist not to certify the ERA. Today, I'm releasing a letter from preeminent legal scholars stating that this Trump-era legal opinion is legally erroneous and should be withdrawn. These scholars also make clear that the time limit in the preamble to the ERA is not an obstacle to ratifying the amendment. This time limit was not included in the amendment itself, and there is no time limit on equality. I strongly agree with the scholar's assessment that time limit is likely non-binding and that Congress clearly has the authority to extend or eliminate time limits if necessary. So today, I call on President Biden, who is a true champion of women, to withdraw this flawed legal opinion and allow the archivist to certify the ERA without delay. I also strongly support the legislation led by my colleague and friend, Congresswoman Spear, that the House passed to eliminate the time limit from the ERA. This would remove even the shadow of a doubt about the ERA's validity. I urge the Senate to take up this bill without further delay. After 100 years, women cannot wait any longer for full constitutional equality. The ERA is not merely a symbol. It will make a real difference in the lives of women and people who face discrimination, sexual violence, and unequal pay. The pay gap between men and women has persisted for decades, with the average woman being paid 80 cents for every dollar paid to men. For women of color, the gap is even wider. In order to make the same income as a man earned last year, a Latina woman in this country has to work an extra 10 months until today, October 21st. That is shameful, and it shows that the current legal standards are not adequate. In 1994, Congress passed the historic Violence Against Women Act, authored by then-Senator Joe Biden, which included a right for victims of sexual violence to sue their attackers. But when a young woman named Christy Brancala tried to sue her rapist, where there was no dispute, it was a gang rape, one even confessed, the The Supreme Court struck down that part of the law as unconstitutional. More recently, a federal court in Michigan overturned a law banning female genital mutilation, which is an internationally recognized human rights violation. The judge found it was unconstitutional to ban female genital mutilation. What a disgrace for this to happen in the United States. With the ERA, Americans who go to court to challenge discrimination will have a fighting chance. Today, equal rights can be too easily rolled back depending on the ideological leanings of Supreme Court justices, but constitutional amendments are permanent. We can't always control who's on the bench, but we can change the document they are tasked with interpreting so that it better reflects the equality that all Americans deserve. This committee will continue to work to put the ERA in the Constitution. I am very pleased now to recognize Congresswoman Jackie Speer, the sponsor of H.R. Res. 17, and ERA champion, for a brief opening statement.
Thank you, Chairwoman Maloney, for holding the first full committee hearing on the Equal Rights Amendment in over 40 years. I know that when the ERA is finally added to our Constitution, it'll be in no small part thanks to your steadfast commitment and leadership and the hard work of so many of the sheroes who are here to testify today. We're here today to acknowledge a sad truth. Our country's founding was based exclusively on excluding women in the Constitution. It was intentional. We were deprived of basic rights to vote, prevented from being hired for most jobs, and from owning property. To this day, we are paid less for our work, violated with impunity, and discriminated against simply for being who we are. The ERA was first introduced in Congress in 1923. That's 98 years ago. Yes, we're here today because nearly a century later, the Constitution still does not guarantee gender equality. We're here today because 193 United Nations countries, 165 of them have an Equal Rights Amendment, but the United States does not. Countries that have looked to us to model their constitutions have recognized the equality of women and men, yet we fail to do the same. We're here today because despite the tremendous progress women have made, we are still deeply unequal in society. In subtle and not so subtle ways, women are subject to discrimination, a reality denied by many of my colleagues across the aisle who insist we don't need the ERA because women are already equal. Well, to them I ask, what do you say to Christy Broncala, who was raped by 2 football players at Virginia Tech? And the court that said that, in fact, Congress didn't have the power to pass that part of VAWA. That's why Section 2 of the ERA is so important. Or how about Tracy Rexroth, whose starting salary at the Arizona Department of Education was $17,000 lower than her male counterpart. They had equal experience, equal education. But she was paid $17,000 less because of her salary history. A federal district court ruled that unequal starting salaries don't violate the Equal Pay Amendment because salary history is an acceptable business reason for unequal pay. Or Jessica Lenahan, whose estranged husband kidnapped, murdered their 3 young daughters after police refused to enforce a restraining order. The Supreme Court ruled that Lenahan had no constitutionally protected right to enforcement of her restraining order. Or how about Peggy Young, who was put on unpaid leave without health insurance by UPS when she got pregnant? The Supreme Court set such a stringent standard that in 2/3 of the cases after Young, courts ruled against pregnant workers seeking reasonable accommodation. If we had the ERA, these cases would have very different outcomes. The ERA will create stronger legal recourse against sex discrimination, empower Congress to better enforce and enact laws protecting women, and confirm the rightful place of gender equality in the Constitution, not subject to the whims of Congress or the White House. It will also ensure that the Supreme Court uses the most demanding standard of review in sex discrimination cases, the way it already does for race discrimination And despite the partisan rhetoric, I believe in my heart that most of my Republican colleagues know that this is not only the recognition of our inalienable rights, but that it is the right thing to do. That's why the Department of Justice must rescind the Trump administration legally flawed and non-binding legal memo on the ERA, and the archivists must immediately certify the ERA as the 28th Amendment, because 38 states have already ratified the amendment as the Constitution requires. I'm also proud to champion H.J. Res. 17, which passed the House earlier this year with bipartisan support to remove any shadow of doubt that the ERA is, in fact, our 38th Amendment. And I urge the Senate to act swiftly. I know that all of us will keep fighting until we achieve the promise of equal justice under law. Mark my words, we will get this done. We must get this done. Our daughters and granddaughters demand it. With that, I yield back.
I'll now recognize the co-chair of the Women's Caucus, a true leader on women's equality, Congresswoman Brenda Lawrence, for her opening statement, and you will.
Thank you so much, Chairwoman Maloney, for your leadership, relentless leadership in working to advance the rights and freedoms of women and girls, both in the United States and abroad. The urgent need for the Equal Rights Amendment is very clear. If I can quote my colleague who stated, Jim Clyburn, that America is only great when its greatness is shared equal for everyone in America. Since our country's founding, women have been intentionally left out of the Constitution. We have been treated as second-class citizens at one time in our history and had to abide by laws that gave us no voice or representation. And for those who still question the need for the ERA, take a look at gender wage gap. Take a look at pregnancy discrimination. Take a look at the loss of reproduction freedoms. As the co-chair of the Women's Caucus, I introduced a resolution that will require our Declaration of Independence to state that all men and women are created equal. At minimum, can we as a country state that we are equal? We need the ERA so that women can achieve our full potential. We need the ERA to ensure that the rights of women and girls will not be rolled back by the political whims of the day, but instead be preserved as the basic rights guaranteed by the United States Constitution. In the words of Abigail Adams, remember the ladies. It would be wise, Mr. President, and for our government to remember the ladies who have stood up and fought, who never stepped down when it came to serving our country and taking care of the least of us. I join today with such pride with all the women who are here today and the witnesses. I look forward to hearing from you who are in the fight, and I thank you, and I yield back.
The gentlelady yields back, and I now recognize the distinguished ranking member, my good friend Mr. Comer, for his opening statement, and ask him to please understand on a personal level, I ran for Congress to ratify the Equal Rights Amendment. That was my goal. And this is the first hearing in a committee, full committee, that I've been able to achieve. So if I spoke a little too long or took the liberty of recognizing two incredible women leaders who have been fighting just as hard as I have for this hearing and for the Equal Rights Amendment, and I certainly grant as much time as the gentleman would like, and if you have two other members that would like to speak, we certainly will recognize your right to do so, and I appreciate your cooperation on postal and on this. Thank you.
Thank you, Chairwoman Maloney, and congratulations on holding this hearing. Hopefully we'll have some hearings that our side has been advocating for, but the message that I want to deliver today, all Americans, men and women, should be treated equally under the law, regardless of their race, religion, or sex. Fortunately, all citizens of the United States are already guaranteed due process under the 5th and 14th Amendments to the United States Constitution and guaranteed equal protection under the 14th Amendment. Federal laws such as the Civil Rights Act of 1964, Title VII, the Equal Pay Act, and Title IX of the Education Amendments of 1972 already prohibit discrimination on the basis of sex in compensation, public accommodations, and federally funded programs. Despite what Democrats are telling us today, the 1970s era Equal Rights Amendment is simply unnecessary and would be redundant of protections that already exist. In fact, one of our witnesses today, Inez Stepman, will testify about the many potential adverse effects that the Equal Rights Amendment would have on this country, particularly on women. By taking away flexibility in our current legal regime that protects women's privacy, safety, and the ability to protect against harassment, the Equal Rights Amendment would usher in a new era of judge-created rules that could negatively impact women. The Equal Rights Amendment could jeopardize programs such as women's shelters and the WIC program. It could force the elimination of sex-segregated public facilities such as women's prisons and public school restrooms. It could also prevent female athletes from being able to fairly compete in sports. Not to mention the fact that the Equal Rights Amendment was introduced 49 years ago, and the deadline to ratify it expired 4 decades ago. Several states even rescinded their ratifications. Whatever your views on the expired Equal Rights Amendment, equality under the law for men and women is already guaranteed by the Constitution and by statute, and rightfully so. Yet, we're here talking about a long-expired proposed amendment. The Oversight Committee should be conducting oversight hearings on the Biden administration or examining legislation actually within our jurisdiction. We should be holding hearings on how the Democrats' COVID-19 shutdown policies disproportionately impacted women and how women are being left out of the already slow economic recovery. We should be holding hearings with the Biden administration officials to find out what they're doing to solve the crises affecting Americans today. This country is facing crisis after crisis, but it's clear that our current political leadership is unable to meet these challenges head-on, even denying they exist in some instances. Whether it's the disastrous withdrawal from Afghanistan, the crisis on our border, rising inflation, or growing supply chain issues, our committee should not remain on the sidelines. I urge the chairwoman to please act on the approximately 20 Republican requests for hearings or investigations we have communicated this Congress. We should be doing our jobs to ensure that our government works for all the American people. Thank you, Madam Chairman, and I yield back.
Gentleman yields back. And I'd now like to introduce our witnesses, and I would like to yield to my good friend, Mr. Conley, to introduce our first witness, and also I would like to now wave on the committee Abigail Spanberger from the great state of Virginia, the last one to ratify the Equal Rights Amendment. Thank you for joining us, Mr. Conley. You are now recognized to introduce your constituent.
Thank you so much, Madam Chairwoman, and thank you so much for having this hearing, because I think it is time. Virginia has acted. I'm glad to be joined by my colleague, Congresswoman Abigail Spanberger, in welcoming a distinguished member of the State Senate of the Commonwealth of Virginia, Jennifer McClellan. Senator McClellan has served the Commonwealth of Virginia for more than 15 years as a member of the House of Delegates and now in the State Senate. She's been a tireless champion for women's rights throughout the Commonwealth of Virginia, a fighter for progress, equity, and justice. Most recently, Senator McClellan introduced SJ 1, Virginia's Equal Rights Amendment ratification. After its passage in 2020, Virginia became the 38th and qualifying state to ratify the amendment to help our country take a major step to join more than 100 nations that recognize equality based on sex and gender in their respective constitutions. We would not have passed the 38th Amendment if we did not feel that we were finally solidifying the ratification, the full ratification of the Equal Rights Amendment by the action taken by Senator McClellan and her colleagues in the General Assembly of Virginia. We're proud of that accomplishment, and we're delighted to have Senator McClellan here, and I know she's going to describe later the process and thinking that went behind that action. Welcome, Senator McClellan. Thank you again for having this hearing, Madam Chairwoman, and thank you for allowing Congresswoman Spanberger and myself to welcome a distinguished Virginian testifying today. I yield back.
Thank you. And after Senator McClellan, we will hear from Alyssa Milano, who is an actor, an actress, a writer, and an ERA advocate. Next, we will hear from Carol Jenkins, who is the president of the ERA Coalition. We will then hear from Inez Stepman, who is a senior policy analyst at the Independent Women's Forum. And then we will hear from Ellie Smeal, who is the founder and president of the Feminist Majority and publisher of the Ms. Magazine. Next, we will hear from Bambi Salcido, who is the president of the Trans Latina Coalition and is a board member of the ERA Coalition. Last but not least, we will hear from Victoria Norse, who is the professor of law at Georgetown University Law Center. The witnesses will be muted so that we may swear them in. Please raise your right hand. Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God? I do. Let the record show that the witnesses answered in the affirmative. With thank you, and without objection, your written statements will be made part of the record. With that, Senator McClellan from Virginia, you are now recognized for your testimony.
Thank you, Madam Chair, Representative Conley and Spanberger, and members of the committee. I'm very honored to be here today. I'm Virginia State Senator Jennifer McClellan. I'm here as a daughter, granddaughter, and great-granddaughter of educators, domestic workers, community leaders, and civil rights activists who struggled for equality in the segregated South. I am here as a mother who does not want to leave the fight for equality to my children, Jackson and Samantha. I am here as a legislator who helped lead Virginia to become the 38th and final state necessary to ratify the Equal Rights Amendment last year. The history of my family and my Commonwealth is one of facing inequities and working to create a better future for the next generation. 120 years ago, my great-grandfather, born on a plantation 4 years after emancipation, had to pass a literacy test and find 3 white men to vouch for him to be able to register to vote. But my great-grandmother couldn't. My grandfather and my father had to pay poll taxes. My mother comes from generations of domestic workers who served vital roles in our society and were often overlooked or treated unfairly and paid very little. And while my father could vote at the age of 22, my mother could not vote until well into her 30s after passage of the Voting Rights Act of 1965. I carried these legacies with me into the Virginia House of Delegates in 2006, at a time when there were only 16 women in that chamber. I felt that imbalance when I became the first delegate to give birth while in office, and was asked if I would resign or retire as a result, while a male colleague who became a father 2 months later was not. For my family, my Commonwealth, and my country, it has been a long march towards equality. And it is a march that has included women of color from the beginning, even when we have often been the last to benefit from our work. Black women, including the founders of my sorority, Delta Sigma Theta Incorporated, in their first public act in 1913, marched for the right to vote in this very city, even when told to march in the back. Black women marched for civil rights in 1965 from here to the Lincoln Memorial, even though not given a speaking role. And women of color have led the way for the passage of the ERA, including Representatives Shirley Chisholm and Patsy Tokomoto Mink 50 years ago when the House passed the ERA. Virginia's ratification was led by multi-generational Black women, Senator Mamie Locke and myself in the Senate, and former Delegate Jennifer Carroll Foy in the House. Nevada's ratification was led by Senator Pat Spearman. Other women of color pushing their states to ratify the ERA include Arkansas Senator Joyce Elliott, Florida Senator Audrey Gibson, North Carolina Representative Carla Cunningham, South Carolina Representative Gilda Cobb Hunter, and Utah Representative Karen Kwan, just to name a few. I was proud to lead Virginia to become the 38th state to ratify the ERA last year. And given our history, it is poetic justice that it was Virginia to put the ERA over the top. In 1619, the men of Jamestown understood that for Virginia to be a permanent settlement, they needed women. So they actively recruited women to, quote, make wives to the inhabitants. And in May of 1620, the first 90 women arrived in response to that call, and their rights were surrendered to their husbands. They could not vote, they could not hold public office, they could not own or control property. African women and men who arrived on these shores in 1619 were considered property and had even fewer, if any, rights. And as you heard, in 1776, when Abigail Adams wrote to her husband as he went to the Continental Congress, she implored him and his fellow delegates to remember the ladies and be more generous and favorable to them than your ancestors. They didn't. Over the past 245 years, we have made progress, slowly. But true equality under the law for women, and especially women of color, has been elusive. With the ratifications of the Equal Rights Amendment by Nevada, Illinois, and Virginia, the states have now done our part. It is now time for the National Archivist to do his and certify the ratifications of these 3 states and publish the amendment. To the extent congressional action is needed, I ask you to take it immediately. It is past time, for the U.S. Constitution to join over 100 constitutions across the world and having gender equality in the Constitution, including every constitution adopted since World War II. It is time for me to stop fighting the same fights that my mother, my grandmother, my great-grandmother had to fight. It is time for me to tell my children, Jackson and Samantha, that the United States Constitution guarantees them both equality under the law. And I thank you for this opportunity to speak today.
Thank you for your testimony. Ms. Milano, you are now recognized for your testimony.
Madam Chair, distinguished members of the committee, thank you for holding this hearing and for inviting me to share some thoughts with you today. While I will speak briefly about the importance of the ERA, this hearing is not a debate on that amendment. That debate is over. We won. The states have directed Congress to amend the Constitution, and now it is the duty of Congress and the administration to get out of the way and remove the arbitrary, unnecessary, and shameful deadline that was cynically imposed nearly half a century ago as a poison pill. Since the earliest days of our nation, women have been fighting, not waiting, but fighting for inclusion in our founding document. From the Seneca Falls suffragists to Alice Paul, from Shirley Chisholm and Gloria Steinem to the inspiring generation of young women and queer activists and allies of the new millennium. We have pleaded for centuries a simple and powerful thing: equality under the law. I want my daughter Bella to grow up knowing she has the same rights as every man in this country, and I want my son Milo and every boy in America to know that too. They deserve a government that cannot treat them differently because of gender. If there is one word which defines the American identity, it is freedom. We call our president the leader of the free world. When we present ourselves to other nations advocating across the globe for democracy and human rights, it is freedom which drives that discussion. There are even members of this very committee who belong to something called the Freedom Caucus. But how can we be a free people when our governing document does not prohibit discrimination against more than half of the population? The answer, of course, is that we cannot. The lack of constitutional protections for anyone who is not a cisgender man is a blemish on the very idea of Americanism.
Alyssa, we're having a technical problem
Oh.
and we need to correct it with the Zoom.
Okay?
We're going to recess just for a moment to try to correct it.
Okay.
Because,
It's the ghost of Alice Paul.
okay. Can you hear me now? Yes, they can hear us now. Okay, great. So we're now back in order, and Ms. Milano, if you'd please continue, and my apologies for this disruption.
Thank you, Madam Chairperson. How can we be a free people when our governing document does not prohibit discrimination against more than half of our population? The answer is, of course, we cannot. The lack of constitutional protections for anyone who is not a cisgender man is a blemish on the very idea of Americanism. As long as the Constitution allows gender-based discrimination, the United States can never achieve the greatness to which it aspires. 85% of UN member states have constitutions which explicitly guarantee equality for women and girls. Madam Chair, if you lived in Latvia or Iceland, you would be assured of having the same rights as the men on this committee. Here in the United States of America, you are not. Today, a white man on this committee will probably ask me which rights American women do not have that American men do. Allow me to preempt that question. There are many current gender-driven injustices in our country. But the Constitution is not simply about the present. The Constitution is about what we bring far into the future. It exists to protect us from the what-ifs. The ERA will outlive every one of us. It is a permanent protection of our most basic rights. Your obligation to the people of our nation, not just today, but in the centuries to come, requires you to take action. The framers failed us when they did not include women in the Constitution. Congress failed us when it added the deadline for ratification of the ERA. You, the members of this committee, have the opportunity and the obligation to fix the Constitution and stop it from failing us. Will you take it? Will you answer the call of history and the promise of the future, or will you continue to allow the enemies of equality to continue to prevent America from being a truly free nation? These are your only options. Thank you for your time.
Ms. Jenkins, you're now recognized for your testimony.
Thank you so much, Chairwoman Maloney, for the invitation to speak here today, and to Ranking Member James Comer as well, and for the entire committee for holding a hearing on this important issue. It is well past time to lift the time limit. It is well past time to talk about the Equal Rights Amendment. And the first full committee hearing since the 1970s is absolutely long overdue. This is an important step for sex equality and for democracy, and we are grateful to be here. And I especially am grateful to be in this room, named for one of my heroes, Elijah Cummings. And I always love one of his admonishments to us, that we can do better than this. And this is what I feel about America and its girls and women. We can do better than this. I'm glad to be here with my board members, Alyssa Milano and Bambi Salcedo, who are leading this effort in this country for equality. My name is Carol Jenkins, and I'm grateful to be serving as the president and CEO of the ERA Coalition and its sister organization, the Fund for Women's Equality. Now, I've been fighting for what I call simple and pure equality, which is the concept of the Equal Rights Amendment, for almost my entire life. This, what I call an agitation for democracy and equality, runs through my veins. I was born in one of the poorest counties in America, both then, when I was born, some time ago, and still today, one of the poorest. It's called Lowndes County, Alabama. It was farm country, just outside of the capital city of Montgomery. They used to call it Bloody Lowndes, where they lynched people for wanting to vote, and much, much less. My cousin sat in at segregated lunch counters and got arrested and brutally beaten for the right to a cup of coffee. My successful businessman uncle bailed Martin Luther King Jr. out of the Birmingham jail as he sat there writing his famous letter that helped change our lives. Our family farm, that Lowndes County farm, was the third stopover in the historic march from Selma to Montgomery. I spent nearly a quarter of a century as a reporter documenting the failure of our democracy and its incremental improvement. And in South Africa, when I covered one of the most spectacular victories of persistence, Nelson Mandela emerging from prison alive and eager, and this was after 27 years of imprisonment, breaking the back of apartheid and releasing millions of black-skinned people from a hellish state-sanctioned way of life. This fight for the ERA has lasted a century. The women and men who have waged this war against discrimination are every bit as determined as MLK and Nelson Mandela, and the rights we are fighting for are equally important. 50 years ago, in 1970, our board member, Gloria Steinem, spoke right here in Congress in a hearing on the Equal Rights Amendment before the Senate and talked about the perpetual falsehood, one we still hear today. She said, "Another myth that women are already treated equally in this society. I am sure there has been ample testimony to prove that equal pay for equal work, equal chance for advancement, and equal training or encouragement is obscenely scarce in every field." She said that 50 years ago. It's still true today. And despite stating the case for the ERA in Congress 50 years ago, Gloria Steinem, Ellie Smeal, glad to be sitting next to another one of our leaders, and many others are still fighting for these same rights in 2021. And women of color, and black women in particular, have always been at the forefront of this movement. Shirley Chisholm gave a fiery testimony right here in the House floor in support of the Equal Rights Amendment. Her support for the Amendment 2 led the way for passage of the ERA in the House of Representatives the following year, 50 years ago. And it was a queer black Episcopal priest, lawyer, and author named Pauli Murray who was the architect of the litigation strategy used by Ruth Bader Ginsburg while arguing in support of a 14th Amendment to the Constitution. This led to Pauli being recognized as one of the mothers of the modern sex equality movement, and her arguments for equality for women included the intersectional take on her own identity as well, calling the meeting of racism and sexism Jane Crow. Pauli spoke about these overlapping identities in her powerful and persuasive testimony on the ERA. Black women have also led the ratification efforts of the last 3 states needed to reach the 38-state threshold required by the Constitution for all amendments. This revived the current fight for the Equal Rights Amendment across states and in Congress. State Senator Pat Spearman, another queer black woman, led the successful charge for ratification in Nevada in 2017. The next to last state to ratify Illinois, saw black lawmakers, including State Senator Kimberly Lightford, then State Representative Latessa Wallace, and then State Representative Juliana Stratton lead the fight in 2018. And of course, as we've heard, in January of 2020 in Virginia, a multi-generational group of black women lawmakers led the ratification of the ERA, including State Senator Jennifer McClellan, who so eloquently and wonderfully led that fight, State Senator Mamie Locke, then State Delegate Jennifer Carroll Foy. Other lawmakers, key lawmakers in Virginia during ratification were Delegate Hala Ayala, an Afro-Latina woman, and Delegate Danica Rome, the first out transgender woman to serve in a state legislature. This movement continues to move forward with black women in places of leadership throughout the advocacy space as well. Many of the organizations that are part of the ERA coalition are in fact now led by black women, including Supermajority, now the League of Women Voters, and others. And the coalition itself is presided over by black women. I lead, and we have 2 board chairs, Kimberly Peeler Allen and Mona Sinha. We are actually a tremendously broad coalition of movements, nearly 200 organizations representing women's rights, civil and voting rights, LGBTQ and trans rights, disability rights, faith groups, and workers' rights, including unions representing airline workers, 80,000 miners, and 350,000 teachers. We are all united in this effort to eliminate discrimination based on sex. The ERA Coalition began providing a collective place for ERA action in 2014, and in these 8 years, we've gathered these nearly 200 organizations as equality partners. We've worked in the states. We were present in the gallery when Virginia became the 38th and final state needed for ratification. We were in Congress with Congresswoman Maloney to mount a shadow ERA hearing in Congress to demonstrate why the time limit needed to be removed. Congressman Jerry Nadler told us that day that if he became chair of the Judiciary, he would give us the real hearing. And he delivered on his promise in 2020. And we were there with Speaker Pelosi and Congresswoman Spear.
Madam Chair.
When the House passed the time limit bill.
Now,
And I will say
your time
as-
is long past, and that was a subcommittee hearing that we had then. But your time has expired, as the gentleman points out, so can you wrap up and, well,
Certainly, I will just say that as the grandmother of 2 biracial children who have 2 mothers, I want this country to reflect their lives. I don't want them to be ashamed of who they are. I want their ability to be recognized in the Constitution of the United States to be true, and I believe the only way that can happen is by enacting the ERA. Thank you.
thank you. Ms. Stepman, you're now recognized for your testimony.
Chairwoman Maloney, Ranking Member Comer, distinguished members of the Committee on Oversight and Reform, I am honored to testify today against the proposed Equal Rights Amendment to the United States Constitution. I currently serve as a senior policy analyst with Independent Women's Voice and the Independent Women's Law Center. Today in the United States, men and women are equal under the law, but crucially, not interchangeable. We do not require that the law treat men and women exactly the same in all circumstances, even when they are incarcerated, in the sports arena, on the front lines of combat, because we understand that in some limited situations, physical and biological differences matter deeply. In those situations, the law is permitted to recognize the very real differences between males and females. In hundreds of everyday instances, that recognition allows women and girls to take advantage of opportunities, compete, and even feel safe. The recognition of biological sex has been a necessary prerequisite for the freedom, prosperity, and success American women have enjoyed these past several decades. These laws have created opportunities for women, maintained our privacy, and even protected our safety in situations where those differences become relevant and come with serious consequences. State, federal, and constitutional law all protect basic sex equality in 2021. Our nation's law books are replete with prohibitions on sex discrimination in education, athletics, housing, employment, including prohibitions on sexual harassment and unequal pay. To the extent that discrimination against women in these areas still exists, it is already illegal, and the ERA will add nothing to the protections that women already enjoy. The ERA, if written into our highest law in an illegitimate amendment process, will not advance the position of women and girls in our society, but instead undermine the successes we have already attained, and even place us in harm's way. For example, incarcerated women have, until recently, been able to rely on being housed in a prison only with other women, on the common sense assumption that it is dangerous to house female inmates with male ones in close quarters, and that co-ed prisons make women vulnerable to physical and sexual assault. But under our current legal protections, the government is not allowed to and should not be allowed to discriminate on the basis of race the way that it does by separating men and women's prisons. In Johnson against California, the Supreme Court held that preventing violence in prisons does not raise to the level of government interest required by the Constitution. If the same strict scrutiny standard were applied to single-sex prisons under the ERA, a conservative interpretation of its legal impact, by the way, women would quickly find themselves at the mercy of male prisoners. These consequences are already happening in states that are allowing male-bodied inmates who identify as female to transfer to the women's prisons, and that policy has already resulted in sexual assaults on female inmates. But the ERA could potentially make the problem far worse by extending that invitation not just to a small percentage of people who are born one sex and identify as another, but to all male prisoners, regardless of identification. After all, quote-unquote, discriminating against men by keeping them out of women's prisons is a discrimination on the basis of sex, exactly the kind of policy a plain language reading of the ERA is intended to prevent. The same rationale could apply to any context in which the government separates or distinguishes between men and women. For example, when selecting a same-sex TSA agent to administer a pat-down at the airport. Similarly, public schools, whether on the K-12 or university level, would not be able to maintain separate bathrooms, locker rooms, or sports teams for boys and girls. Universities would not be able to maintain separate dorms for male and female students, and campus-connected sororities and fraternities would potentially become overnight constitutional violations. A boy whose 100-meter dash time qualifies him for the girls' team, but not for the boys' team, is kept off the former only by a quote-unquote discrimination on the basis of sex. Again, we are dealing with the ramifications of accommodating individuals whose gender identity does not match their born sex in all of these contexts already. But the ERA would throw the doors wide open to all males in these settings and more. Recognition of biological reality is not bigotry or discrimination. When we treat men and women as though there are no differences in size, strength, and otherwise between them, we create more female victims. Equality between men and women doesn't mean treating us exactly the same. Treating males and females exactly the same, regardless of biology, privacy, or circumstance, hurts women and girls. In 2021, the ERA has no upside. The language might sound nice, but it will not improve women's lives. To the contrary, by prohibiting public policy from ever taking into account biology and common sense, and by short-circuiting debate through an illegally rushed process, the ERA would deny the 62% of the electorate who weren't of age or born when we last considered the consequences of the ERA a chance to weigh in on the question of whether women and men should be treated identically in all circumstances. And by the way, the majority of that electorate is women. The ERA would harm women and girls, and I urge you to vote against its much-belated resuscitation.
Thank you. Ms. Smeel, you are now recognized for your testimony.
Thank you. I'm Alyssa Milano, President of the Feminist Majority.
Excuse me, you don't have your microphone on and we can't hear you. It's the red button in front of you. Great.
Thank you very much. And thank you, Chairwoman Maloney, for your years and your persistence and your leadership and your dedication to the ratification of the Equal Rights Amendment and to placing it in the Constitution. Your leadership has been marvelous for all in this country, and I'm so happy about being here today. I am honored to work with you and this committee in asking for the ERA to be certified in the Constitution. I started, but you already said it, and I'm going to say it again. The Equal Rights Amendment is 52 words. It is simple. It's equality of rights under the law shall not be denied or abridged by the United States or any state on account of sex. The second clause is short. Congress shall have the power to enforce by appropriate legislation the provisions of this article. And finally, the last section, one sentence, this amendment shall take effect 2 years after the date of ratification. I have worked for the passage of the Equal Rights Amendment for over 50 years. The arguments that you have just heard, I have had to listen to for over 50 years. I know what side I've been on, because while we've been fighting for gender equality to be placed in the Constitution, we've also been fighting day in and day out to empower women and girls and to win gender equality for all. The Feminist Majority and the Feminist Majority Foundation are both dedicated to this principle, and we've worked on all kinds of programs. But let me just go a little bit in my history on the Equal Rights Amendment, and you will see why I feel so deeply about this. I began my work as a young chapter activist in Pittsburgh, Pennsylvania of the National Organization for Women. I was really lucky. That chapter had the national president, Wilma Scott Heide, and the national coordinator, this is now 1970, of the task force to pass the Equal Rights Amendment, Jean Witter. And why do I say their names? I'm going to try to pepper more names in, because thousands and thousands of people have fought for this amendment and have fought, while they were fighting for it, for equality in many other ways. Our chapter got rid of help want ads, men and female. We sued the Pittsburgh Press at that time, but we only won by a 5-4 decision, even though it was blatant prima facie discrimination. Only 20 jobs different jobs advertised for the women and several hundred for the men. Now, in fighting, we also passed the Pennsylvania Equal Rights Amendment, which was one of the strongest state ones. We fought in state after state and now have them in over 24 states. At the same time we did that, just a small group of women broke up the hearing for the 18-year-old vote, so there would finally be a hearing in the Senate on the Equal Rights Amendment. The reason it's taken so long, this 100 years, is we lost about 50 of them, and I mean 50 of them, with very bright, wonderful leaders. How did we lose it? They boxed it up in committee. They wouldn't allow a vote. In fact, to get the first vote and the only the vote to ratify in the House took 50 years because it was boxed up in the Judiciary Committee and they wouldn't allow a vote. And why wouldn't they allow a vote? This has been so popular. They knew it would pass overwhelmingly when in fact it would be placed on the floor. And when it was, after a discharge petition by Martha Griffiths, and I had the pleasure to work with her at the very beginning of my own career, it was passed 354 to 24 people. Overwhelmingly, I would say, bipartisan. To get the hearing, to get it going in the Senate, we disrupted the hearings of the 18-year-old vote and got a promise from Birch Bayh, the co-sponsor in the Senate, or the major sponsor in the Senate, that he would finally hold hearings on it. And so in 1972, we won 84 to 8. These are not close votes. Because why? We were way ahead in the polls. People wanted equality for women. But we had to keep fighting. And at first it went really, really fast. But it got bottled up again and delays. For example, we're all grateful for the 38th state of Virginia ratifying, but we should say, what happened in Virginia? It was bottled up in the Privileges and Elections Committee of the House for about 50 years. And when it comes out, we passed it. But they didn't come out until the year 2020. Bottled up. Now, what happened in between? I hear all the time about Title VII, Title IX. We worked to put those things on the books. Feminists worked. But one of the things they keep on saying, you have all these guarantees. But what they don't say is that along the way, and we had a hard time on this at first, we now don't have that hard time, but is that others tried to defeat and undermine Title VII and Title IX. In fact, Title IX, by the Reagan administration, was gutted by the Grove City case. I don't have the time to go into that whole case, but we had to work to restore it and pass an amendment to restore it. Same thing with the Title VII. The Roberts Court gutted it.
Madam Chair.
The gentleman is pointing out that your time has expired, and
Okay.
you have pointed out very important reasons why we need it, because it can be rolled back and overturned. So thank you for that, but all your testimony will be in the record. I now recognize Mrs. Salcido. You are recognized for your testimony.
Thank you, Madam Chair. Primero que nada, quiero dar gracias a mi Creador, mi poder superior, por darme la oportunidad de estar con vida un día más. También quiero honrar la tierra en la cual estamos aquí hoy en día y pedir permiso a la gente Natochcan y Pescatahua que me permitan decir unas palabras en su tierra. Greetings, everyone. I know that it was hard for some of you to understand what I just said, but it is customary for me that before I speak, I acknowledge my Creator for allowing me to breathe one more day. I also honor the land where we're standing today, and I ask permission from the Natochcan and the Piscataway peoples to allow me to speak in their land today. I'm humbly grateful to be in your presence today. Thank you, Chairwoman Maloney, and members of this committee, for allowing me to share my experience, strength, and hope with you today. My name is Bambi Salcedo, and I'm a very privileged trans-Latina woman who has the honor to be the president and the CEO of the Trans-Latina Coalition, a national advocacy organization based in Los Angeles that also provides social support and life-saving services to gender, to trans, gender nonconforming, and intersex people. I also serve as a board member of the ERA Coalition. My experience is that of a person who has had the opportunity to survive many horrific experiences simply for being who I am. A trans woman who is Latina, an immigrant, someone who has overcome constant discrimination, multiple sexual assaults, homelessness, drug addiction, including overdoses, and left for dead in alleys. I spent over 14 years of my life incarcerated. I have been chased out of neighborhoods and beaten. I had to do sex work as means to survive. I had guns pointed into my head. I committed multiple suicide attempts. I experienced all of this because I was pushed by our society because there were no laws or protections against discrimination to protect people like myself. I can honestly say that I have survived things that you probably are not able to imagine. But what is most unfortunate is that the same issues that I have endured and overcome, many members of my community are experiencing today all across the country. Even in California, which is the state that has the most inclusive legislation to protect trans people. 2021 will be a record number of murders in the trans community. I have seen many of my friends die. I have organized more funerals than celebrations in my community. All of this because we have no national legislation that will serve as a protection for all people. I know that you're probably going to say, what about the Equality Act? The truth is that the Equality Act does not look at all of the intersections across my life and will not provide constitutional equality. For example, I am glad that my friend Monica Ramirez started Latina Equal Pay Day, which we're acknowledging with sadness today. As a trans Latina woman, the pay gap is enormous. The discrimination that we experience while trying to get employment in the workplace is rampant. The Equality Act would not support other trans women and me obtaining employment and being compensated and valued equally for our work. The Equal Rights Amendment will help ensure no discrimination against all peoples, poor, indigenous, Black, trans, women, all peoples. My strength is that I get to share with you who I am and what I have overcome, and how people have uplifted me and supported me to heal my wounds, which unfortunately our government has failed to do. My strength is that I speak to you with my truth because my truth is my power. My hope is that you understand the opportunity that we have in this moment in time, that you understand that the Equal Rights Amendment is what our nation needs right now to heal the intergenerational wounds generated against the most marginalized. I hope you open your hearts and your minds and you do the humane thing to do to ensure that all peoples, not only those who are like me, have the rights that we deserve, that we get to be acknowledged as the human beings that we are, that we're giving some dignity, and that we honor the work of many people who have tried for more than 5 decades to ratify the Equal Rights Amendment. We have an excellent opportunity to support all peoples and not just some. While I support the Equality Act and its passage, the ratification of the Equal Rights Amendment nationally needs to happen. I hope that I get to see the passage of the Equality Rights Amendment in my lifetime. Every day, I'm afraid that I can be killed simply because I am a trans woman. I ask that you see that there's no other time like what we have today, that we do not continue to see divisions, nor continue to feel messages that say some people are more deserving than others, but rather that we see people in this country need to be protected and valued, and to use your power to ensure the affirmation of the Equal Rights Amendment. There's no time like with the present, and the time to act favorably about the Equal Rights Amendment is now. Please be on the right side of history. Only you can do that for yourself. And many people depend on you to do what is humane. I am sure that generations to come will see then who are the people who understood what human and civil rights are, who use their power for the betterment of all peoples. Today is a historic day, and I want for you to ask yourselves, do I want to be on the right side of history? I hope your conscience says yes. I invite you to imagine a new world, a world of constitutional equality, and freedom for all. Thank you so much for the opportunity to be in your presence today.
Thank you. And Professor Norse, you are now recognized for your testimony.
Thank you, Chairwoman Maloney and Ranking Member Comer. It's a delight to be here with these wonderful women, and thank you for your leadership. My name is Victoria Nurse. I'm the Ralph Whitworth Professor of Law at Georgetown, and I write and teach about constitutional and statutory interpretation. I ask my constitutional law students to read the text. It's a beautiful text of 4,000 words. But then I ask them what is absent from the text. And I say, well, does it say anything about sex discrimination in work? Could you be fired because you're a woman or a man, for that matter? And they look very hard in the text, and they are disappointed to find nothing. Now, I understand there have been people here talking about rights being protected. They're talking about statutes. Those statutes can be taken away by Congress, and they can be declared unconstitutional by the Supreme Court. Justice Scalia was quite candid about the text of the Constitution. He was a great friend of Georgetown. And he would come to the law school and talk about the text of the Constitution and the 14th Amendment. Now, he was very candid when he gave an interview. And he explained that the words equal protection, the 14th Amendment has been mentioned today, do not cover women. This is what he said. Certainly, the Constitution does not require discrimination on the basis of sex. The only issue is whether it prohibits it. Nobody ever thought that that's what it meant. He's referring to the 14th Amendment. Nobody ever voted for that. If the current society wants to outlaw discrimination by sex, hey, we have things called legislatures, and they enact things called laws. Justice Scalia told women to look to Congress, not the Constitution, for their rights. Recently, I watched the brave testimony of gymnasts Simone Biles, Allie Raceman, Maggie Nichols, and others who testified about their sexual assault and why the federal government had done so little, how the law had failed them, how they were disbelieved and ignored. It was something of a déjà vu for me. 30 years earlier, in the year 1990, I was a very young baby lawyer sitting behind a man named Joe Biden on the Senate Judiciary Committee. And I listened to emotional testimony like that of Bambi today about how the legal system had treated them as second-class citizens. It's been 30 years since that testimony, and yet those brave Olympians were saying the law still did not protect them, that the FBI had turned a blind eye. And I knew the deep reason for this. Why? It resides in the Constitution. And let me explain that. In 1994, Congress passed a bipartisan bill that might have helped many sexually assaulted and harassed women of color, of sexual orientation, and that would have included the Olympians or the survivors of Weinstein and others. The original Biden Violence Against Women Act included a civil rights remedy. So you could go to civil court. If the criminal justice system doesn't work, go to civil court. Women did not need to go to the FBI. If the criminal justice system treated them poorly, they had justice in their own hands. And it worked for 6 years. But then in 2000, guess what happened? The Supreme Court struck it down. So a future Supreme Court, as Ms. Milano said, you don't need to be a constitutional law professor to realize that the Supreme Court can strike down a law passed by Congress. In Morrison, the court said not under the Equal Protection Clause of the 14th Amendment nor under the Commerce Clause did Congress have the power to enact a civil rights remedy to protect against sexual violence and harassment. Now, I urge Congress to rethink this. I know that President Biden supports this remedy, but the moral of my story is much broader. It's about the Constitution. We now have a court of 9 unelected men and women, 6 of whom idealize Justice Scalia. The 6 justices who have publicly aligned themselves with him have a judicial philosophy. And I've debated Justice Barrett before when she was a law professor. She's a lovely woman, but she has a judicial philosophy that she thinks insulates her from bias. And that judicial philosophy is known as textualism or originalism. I write about this, I study it. What that means is if it's not in the Constitution, it doesn't exist. This is a new theory. No one ever told me in law school about it. So even if there are precedents on the books that were mentioned by one of the witnesses and by Mr. Comer about the 14th Amendment, there's no guarantee that this court will not overturn them. So ladies, and to my daughter and to my son, be afraid. Other than the 19th Amendment, which gave women the right to vote, women are not recognized in the Constitution's text. Without the Equal Rights Amendment as a constitutional insurance policy, all of the things that women take for granted could simply go away with a vote of 5 men on the Supreme Court. Unequal protection is not a fantasy, it is a reality every day for women who are harassed, sexually assaulted, the victims of domestic violence. Harassment with impunity structurally protects racial and age discrimination as well. It is no wonder that interest in the ERA has mushroomed in the Me Too Time's Up era. Young women know.
Madam Chairman.
Let me just say one final word about this amendment. The time limit was in the preface to the amendment, not in the text. So when the 38th state ratified, it was ratified. If necessary, Congress has the power to extend the deadline, but that is only if necessary, and the OLC opinion, in my view, has no legal validity, and it is not law. Thank you.
Thank you for your testimony. I now recognize myself for 5 minutes for questions. The effort to adopt the ERA is more than 100 years in the making. The century of work for constitutional equality shows how important it is to women and how tenacious we are in working for it. On October 12, 1971, 50 years ago, the ERA passed the House. It was widely popular on both sides of the aisle. And even today, in today's extreme polarization, the ERA is still incredibly popular with the American people, both Democrats and Republicans. Professor, we know it's been ratified by the requisite number of states, and I believe it already should be part of the Constitution. Professor Norris, as a constitutional legal scholar, is there a constitutional role for the executive branch in the amending process?
No, and the Supreme Court has so held.
And Professor, the Trump administration issued a legal opinion claiming that the ERA cannot be certified and that the time limit cannot be extended or removed even by Congress. Is this memo binding legal precedent?
No, it is not binding legal precedent. I actually believe that the administration of no president, whether Republican or Democrat, has legal authority to issue a binding constitutional opinion on Congress's authority because Article 5 only mentions Congress. The president has no role.
And do you agree with the memo's assertion that the time limit cannot be extended or removed?
I disagree with that. I think that it is, as the Article 5, the text of Article 5 says Congress. This is in Congress's authority, and that there are precedents as well that that memo is inconsistent with respect to extending the deadline.
And thank you. I agree with you that the Trump opinion blocking the ERA is legally erroneous and should be withdrawn. Ms. Smeal, you've been at the forefront of this fight from the beginning. Why is the ERA still necessary after all of the progress that you have fought for and that we've been able to achieve? Do we still need it today? Can you turn on your mic because it's not on? Okay.
Yes, we need it, and what I was trying to say is that statutes can be easily changed, and they have been. Title VII and Title IX have been changed. None of them are complete, and we cannot rely on the 14th Amendment or the Interstate Commerce Clause. The Violence Against Women Act had a section in it which said that the victim or the survivor could take a federal action, a civil action, to get damages in federal court if no one would defend her or if it was inadequate at the state level. That was declared unconstitutional. The ERA would give a survivor of sexual violence a chance in the federal courts. And it was very clear that this gives the power to Congress to enforce it through appropriate legislation. Without it, Congress doesn't have the power. Everything is always a little bit here, a little bit there. For example, the Affordable Care Act prohibits sex discrimination in pricing and benefits. Before it passed, the typical health insurance plan for a woman did not cover maternity. And the typical plan, a woman was paying between 150% and 200% more for similar coverage, but no maternity coverage. This was outlawed by the Affordable Care Act, but you know that they're trying to reverse it, reverse it, reverse it. I could tell you other insurance policies. Insurance is regulated at the state level, but a state can't discriminate either. Life insurance, annuities, auto insurance, all have sex discrimination tied into it, costing average women totally billions and billions.
All of this is so important. Please place it in writing for the record. I only have a few seconds left, and I wanted to ask our friend from Virginia, Senator McClellan, you were so active in getting it passed. What did it take to get it ratified in Virginia? And did the ratification effort have bipartisan support? Can you share that with us?
Thank you, Madam Chair. It took persistence, and it had bipartisan support from the beginning. The resolution passed the Senate many times, sometimes carried by a Democrat, sometimes carried by a Republican, and was always bottled up in a subcommittee of the House Privileges and Elections Committee, never making it to the floor. When the majority changed and the leadership changed and it was allowed a vote in the committee and on the floor, it got bipartisan support in both chambers.
Thank you. It's clear that the ERA is not only relevant, but it's necessary, and I urge the archivist to formally certify and publish the ERA as a 28th Amendment to the Constitution. I want to thank all of you. My time has expired, and I would now like to recognize the gentleman from Ohio. Mr. Gibbs is now recognized for 5 minutes.
Thank you, Madam Chair. First of all, I'd like to associate myself with the remarks made by Ranking Member, his opening remarks, Ranking Member Comer, about the reason for this hearing, and also I believe the 5th and 14th Amendments guarantee equal protection under the Constitution. And I also like to associate myself with his remarks. We're facing multiple crisis emergencies caused by the Biden administration's policies, inept policies, and they really require the attention of the Oversight and Reform Committee, and where I think we actually do have jurisdiction. And, you know, our families are being beat up right now with inflation and higher costs of living and their concerns, and we're not having any hearings on those crises. We really should, Madam Chair. I want to take a little bit of a different angle here. We talked so much about how we've come in this country in the last 100 years of women's rights and equality, and I don't think there's a person that would disagree, certainly not in Congress, that it's very bipartisan, that we all think that women should have equal rights. They should have equal pay for doing similar type of work. They should be able to vote. Those aren't debatable. That's we all believe that in our hearts. And the concern I have, even the late Justice Ruth Bader Ginsburg talked about, you know, we really need to start over the process because it's been so long, so many things have changed, and I have a concern that we talked about, it's not in the Constitution, but there's lots of laws out there protecting it, like Title IX, you know, equal pay. You know, there's a lot of things out there that protect women, and there's a debate, or concern, I should say, because it hadn't really been a debate, because under the, like Madam Chair said, you said that the Al-Qaeda saw just enacted now because all these states have ratified it, even though we have 5 states, and I think 4 states rescinded that before the deadline that was actually when it was during the process, you know, nearly 40 or so years ago. So I think that, you know, we do need to debate to make sure that we don't do something that's going to harm women's rights with all the process we've made in this last 100 years. And because let's face it, even since this was proposed back in the 70s, and of course it was originally written, as you said, almost 100 years ago, a lot of things have changed, and we've come a long ways, and we don't want to, you know, have unintended consequences. So I would ask Ms. Stepman, is it not true that the U.S. Constitution already guarantees equal protection under the law for universal suffrage for women? Correct? Just kind of yes or no?
That's correct.
Okay. Also, Civil Rights Act. An Equal Pay, Civil Rights Act of 1964 and the Equal Pay Act of 1963. It's already illegal under all these federal laws to discriminate against women. Is that correct?
That's correct, and it's illegal in the states as well.
Okay. Is it also correct that, or true, I should say, or correct, that prior to the 1979 deadline, Idaho, Kentucky, Nebraska, Tennessee, and South Dakota rescinded their earlier past ratification?
Yes, except I think South Dakota just had a sunset clause on theirs. Oh. One of them, I can't remember which one, honestly. I'm a little under pressure here, but one of those states had a sunset.
Well, it just is. The other side of the aisle keeps talking about this, I guess 3 states ratified it recently, and now the Al-Qaeda saw it just enacted into the Constitution. And how about the states that decided maybe there was issues, they made a mistake and they rescinded it? And they actually, like I said, some of those states actually did it before the dedeadline. So it seems like to me that's be an open and shut case that it hasn't been ratified by the required amount of states. Also, in your written testimony, or you've written, not in your written testimony, I should say, Ms. Stepman, in your previous writings, you talked about the Equal Rights Amendment could take away flexibility that protects women's privacy, safety, and ability to protect against harassment. Can you describe some of the flexibilities that currently exist that would be jeopardized by the Equal Rights Amendment, especially if decisions and interpretation were left to the courts?
Absolutely. So the ERA could have a lot of consequences for women and girls because this current regime, even though we do have equal protection under the 14th Amendment and all of the civil rights law that you listed, Congressman, unfortunately, the ERA would make it inflexible, right? So what we have right now is a regime that protects women's equality with men, but still allows in certain limited, very limited situations, those situations in which our biological differences are actually relevant, that there is flexibility in the law to recognize that. For example, as I mentioned, in prisons, when we separate boys and girls in locker rooms in public schools, right? All kinds of, when we have TSA pat-downs from members of the same sex, these are all ways in which the law has flexibility right now to recognize that in some situations it makes sense to distinguish between men and women because we are biologically different, and ignoring that fact does not help women and girls.
I totally agree, and my time's up. I just say, Madam Chair, that we ought to really take the advice of late Justice Ruth Ginsburg, that we ought to really start the process over and have a debate and make sure we do the right thing and don't err by having unintended consequences. I yield back, Madam Chair.
The gentleman yields back, and I'd like to briefly address the issue of rescissions that he brought up. For hysterical comparison, 2 states attempted to rescind their ratification of the 14th Amendment, but they were rejected by Congress, and the 14th Amendment was certified and published. It's also important to note that the validity of rescissions has never been affirmed by the Supreme Court. I now recognize the gentleman from Massachusetts, Mr. Lynch. You're now recognized, Mr. Lynch.
Thank you, Madam Chair. I want to thank you also for holding this hearing and for assembling such a distinguished group of witnesses, and I am thankful for their testimony. I'd like to use some of my time to explore how certifying the ERA would actually help the United States meet its international obligations. As most of us know, in 1980, President Carter signed the International Convention on the Elimination of All Forms of Discrimination Against Women. However, as we all know, the United States did not ratify that convention. And as well, in 1992, the United States did ratify the International Covenant on Civil and Political Rights, which in part does require the United States to take steps to prevent sex discrimination and gender-based violence. But we seemingly remain in non-compliance. So I know that Professor Norse and Ms. Jenkins and Ms. Smeal have been working on this issue for a long time, but how would the passage of the Equal Rights Amendment help the United States meet its international obligations? Ms. Norse, maybe you could take a first crack at this. Thank you.
Thank you for making that point. I think it's very important to meet those international obligations. We are not in compliance with a variety of international treaties. You know, one of the things that I find surprising is that so many democracies in the world, as mentioned by other witnesses, have an ERA, and we don't. We purport to be the greatest democracy in the world. They have not had their women, you know, had such great difficulty with it. I think that it would be very important for our international obligations. And I'll just mention that I think that the premise that this would hurt women is incorrect, because the premise depends upon an assumption about how a Supreme Court might interpret the law, which is incorrect. And I can talk about that if anyone would like to hear me on it.
Thank you. Ms. Jenkins, I know you've been working on this for a long time, and you've been fighting for women's rights globally. Again, our international obligations and I would say our moral authority around the world, how would that be affected if we fail to adopt the ERA?
Well, we already are in very low esteem around the world, I would say, because of our failure to have the Equal Rights Amendment, our failure to join CEDAW, our failure to participate in equality. I think that we've reached that point where we no longer can stand in the bully pulpit and tell other countries what to do about equality when we have performed so poorly ourselves. And, you know, I think that, you know, this century-long fight, you know, is just demonstrative of, you know, many people ask us, and I'm an activist, not a lawyer, but I'm saying many people ask us, why does America hate its women? Why does it not want to give them equality? Why do they have to beg? Why do they have to take to the streets again and perpetually to ask for this non-discrimination, for the ability to be a first-class citizen and not perpetually left out? I think if you say that all of these other, well, this statute is working and that one is working, and I say, tell me, you know, why are most of the impoverished of our country poor women? You know, why are they women? Why are most of the families headed by women, trying to feed their children. 1 in 3, children in this country is food insecure. So I think that if we go again back to, as I like to say, that if you're looking for the root of sexism and misogyny, you will find it in our Constitution, because it was intended for a certain class of people who don't represent the people who are on this panel and in this room today. So I think that we really, really, as a country, need to rehabilitate ourselves. We fixed the Constitution 27 times, so we know that it wasn't perfect. It needs to be fixed one more time so that women are not second-class citizens. And it's a shameful exhibit, of ourselves around the world, and I thank you for the question.
Thank you, Madam Chair. I see my time has expired, and I yield back.
The gentleman yields back. The gentleman from Wisconsin, Mr. Grossman, is recognized.
Thanks for calling on me. Well, as Ms. Fletcher step in a couple of questions. First of all, I'm looking here at a study mentioned by Heritage Foundation. They claim that unmarried childless women under 30 who live in cities earn more than their male counterparts, their peer group. Do you believe that's true, and could you comment as to why you think that's true?
Yes, I do believe that's true, and that's because the wage gap that keeps getting mentioned during this hearing is due overwhelmingly to different aggregate choices that men and women make in their careers with regard to hours worked, with regard to which college majors they choose, and many, many other factors. In fact, the Obama Department of Labor, so the Department of Labor under the Obama administration, put out a meta-study that looked at a bunch of different analyses and studies of the so-called pay gap, and found that overwhelmingly that gap is explained by women's choices in terms of what fields they want to go to and how they balance family and career. So it makes perfect sense that young women who do not have children, who are unmarried, who are working in a similar way as young men do, would end up closing that gap, and in some cases even exceeding it, because women actually get the majority of college and higher degrees at this point. So that's not surprising.
Okay. Looking at some other statistics here, it says here that 93% of the workplace fatalities are to men. Do you believe that statistic, and do you want to comment on it?
Sure. That's likely because men choose more dangerous employment than do women. And in fact, another one of the points that was brought up earlier today by one of my fellow witnesses with regard, for example, to health insurance costing more for women before the Affordable Care Act, well, car insurance costs more for men because men have more car accidents. These are not instances of sex discrimination or bigotry. These are instances in which men and women behave as large groups, and there are always individual exceptions, but as large groups and in aggregate behave differently and choose different life paths, different careers. I don't find this to be a negative thing. I think it's a positive thing that we live in a country that is free and prosperous, where women and men can choose their own paths, even if they happen on aggregate to be different from one another.
I wasn't going to ask this question, but something Ms. Jenkins said caused me to look at it, and I'd like you to comment on this. It says here that 70% of the homeless in our society are men. You want to comment on that?
It's just yet another example that on aggregate, we should expect that men and women will take different life paths, both in the positive and negative, because there are many real biological differences between men and women. That doesn't mean that we are not fundamentally equal, that we shouldn't be equal under the law, but we do have to have a law that's flexible enough to recognize when those are instances of actual invidious discrimination, where somebody is preventing a woman from doing something simply because she is a woman, or it's one of those situations in which men and women differ, and those differences are actually relevant to the situation in question.
This is, again, something I can't vouch for it, but Uber, hires people. They got some men, some women driving. Apparently, there's a study, and there's apparently a pay gap in which the men who work for Uber are making more than the women. Do you want to comment on that? Could that possibly be true? And are there any conclusions you draw from it?
Sure. Uber pays by algorithm. So there is no possibility for any kind of intentional discrimination between men and women, male and female Uber drivers. In fact, that 7% pay gap that they found among their drivers differing by sex was the result of, frankly, women driving a little bit slower on average and a couple of other factors than do men, right? So again, we're seeing that these gaps emerge. And I would point out that a lot of these countries that are being brought up, like Iceland or Sweden, who have ERAs, the wage gap exists there too. Because these gaps do naturally arise when men and women make different decisions. And I don't know why the male standard of what decisions they make in their career is the standard that female success is pegged to. I think women having the freedom and opportunity to make their own choices is actually what we're after by true equality here. And I think the ERA would actually interfere or destroy that kind of true equality that women and men do have in this country.
Okay. Thank you.
Thank you. The gentleman from Virginia, Mr. Conley, is recognized. Mr. Conley?
Thank you, Madam Chairwoman. Professor Norse, Article 5 of the Constitution reads, and I quote, "The Congress, whenever 2/3 of both houses shall deem it necessary, shall propose amendments to the Constitution, which shall be valid to all intents and purposes as part of the Constitution when ratified by the legislatures of 3/4 of the several states." Is that correct?
That's correct, and thank you for reading the text.
Thank you. Yeah, the text always helps. Is that text in any way modified or refined by any other language?
No.
No. Has the ERA, in fact, met that standard? Have we, in fact, seen the amendment approved by 2/3 of both the House of Representatives and the Senate?
Yes.
And has the ERA been ratified by the legislatures of 3/4 of the states?
Yes.
Virginia being the 38th. Is that correct, Senator McClellan? You can confirm that.
That is correct.
So have we not met the standard of the Constitution?
We have met the standard of the Constitution.
Well, why wouldn't it be subject to the same criteria as the preceding 27 amendments to the Constitution?
It should. You know, it took 203 years to get the Congressional Pay Amendment, so I think the only argument here is about delay, and delay is not, timing is not written into the text of the Constitution.
So we had statutory language putting a time limit in the preamble to the language of the amendment itself. Is that correct?
That's correct. It's in the preamble.
And what is your opinion about the legal binding nature of such statutory limitation?
I think Congress has plenary power to read that as it wishes, so that it appears to me to be precatory or advisory language. That is not what the states ratified. They ratified, if you look at the amendment itself, there's prefatory language, and then it says article, and there's section 1, 2, and 3. That is what the states ratified, not the deadline.
So we have a real live example in front of us. Virginia, my home state. Senator McClellan, can you enlighten us, when you and your colleagues looked at the ERA, given what Professor Norse just said, how did your colleagues look at the prefatory language in the statute versus the actual text of the amendment in front of you? And why did you decide you could proceed?
We looked at the prefatory language as not the amendment itself, and nothing in the Constitution discusses time frames, time limits, or even if they would be valid. And so we looked at the text of the Constitution, and what it told us to do was ratify the amendment. That's what we did.
And it isn't that you ignored the language. You took it into account, but you made a decision it wasn't controlling.
That's right.
And therefore, there was no impediment from your point of view. I don't mean to put words in your mouth. I'm asking. There was no impediment to your actually acting in ratifying the amendment?
That's right. The states are told by Article 5 to ratify. There's nothing in the amendment process in the Constitution about deadlines or rescissions, and we did what we were authorized to do under the Constitution.
And did you, in ratifying it, assume that by becoming the 38th state, you, in fact, had enshrined this amendment into the Constitution?
We did.
Thank you very much for that testimony. I just want to say, Madam Chairwoman, that the ranking member mentioned rescission. And I think that's a bugaboo that needs to be punctured, if I'm mixing my metaphors. When we go down that road, we go down the road of, let's rescind the 13th Amendment ending slavery in America. Let's, in fact, rescind the first 10 amendments to the Constitution of the United States that were adopted or promulgated by the first Congress with the aid and attention of a great Virginian, James Madison. Because, I don't know, we've changed our minds. Where does that end? We simply, just like secession, rescission is not a provision provided for in the Constitution of the United States. In the case of secession, we fought a bloody, terrible civil war to make that point. Hopefully, we don't have to do the same about rescission. I contend, based on this testimony, that the ERA is now an amendment to the Constitution duly ratified by the 38th state, the Commonwealth of Virginia. I yield back.
The gentleman yields back. The gentleman from Louisiana, Mr. Higgins, is now recognized. Mr. Higgins.
Thank you, Madam Chair, and I respect your endeavor through the years in support of the ERA, and I respect my colleague, Mr. Connolly's position. Let me attempt to interject a reasonable proposal that perhaps could be embraced by both sides of the aisle. Let's begin with the Civil Rights Act of 1964, which banned employment discrimination on the basis of race, color, religion, sex, and national origin. The Section 1 of the 14th Amendment, 1868, states all persons born and naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process or law, nor deny to any person within its jurisdiction the equal protection of the laws. The text of the Equal Rights Amendment, Section 1, significant section, states equality of rights under the law shall not be denied or abridged by the United States or by any state on account of sex. Now, you'll see a repetitive theme here. It's the endeavor of our country as we move forward with our journey as a nation to embrace the rights and protections of every American citizen, indeed of every child of God that lives upon American soil, and we support that. Now, in 1972 and in 1976, with slight variance, about 80 million Americans voted in the presidential elections. The average age of voters at the time was 44 years old. The 1976 presidential election, the era of the ERA, that was 45 years ago. Average age of the voter, 44. It means 1976 voters would be 89 right now. The average life expectancy in America is 79. Here's the reality to my colleagues on both sides of the aisle. The Americans that had an opportunity to vote in the sovereign states, and we are a representative republic of 50 sovereign states, those Americans that had the opportunity to vote for ratification of the ERA have mostly passed on to their final reward. Now, may I submit to you that reflective of, my own perspective, I'm the seventh of 8 children. I have 6 sisters. I have 3 daughters, 2 living. And I have an amazing wife. And let me just say that I support the Equal Rights Amendment. I don't have a problem with it. It's a bit repetitive to existing law, but okay. The women of our country deserve this message of respect and for it to be permanently etched in our founding document. My father taught me long ago, I was just a young lad. He said, son, the wisest words ever assembled are yes and ma'am. You'll save a lot of trouble during the course of your life if you learn to say yes, ma'am. So I say to the ladies present and to our good chairwoman, yes, ma'am. Move forward by all means with the Equal Rights Amendment. But from the words of Ruth Bader Ginsburg, let me encourage you to consider her words. In 2020, I'd like to see a new beginning. Ginsburg told an audience at Georgetown University Law Center, I'd like to see it start over regarding the ERA. In 2019, she said, I hope someday it will be put back on the political hopper, starting over again, collecting the necessary number of states to ratify it. She said last year, that was in 2019. May I submit to you, do it right. Say yes, ma'am, to this generation of women from sea to shining sea. Give them an opportunity to vote to ratify the ERA. May I submit that if the ERA was resubmitted to Congress, it would pass by a wide bipartisan margin, and if presented to the states for ratification, I propose that all 50 states would ratify the ERA, and it would be done now with voters that live now. Do it right. You want to pass the ERA, by all means, move forward. I would support it. If my daughters support it, my wife supports it, and my sisters support it, then who am I to stand in the way? I would support it, but do it right. Madam Chair, I yield.
The gentleman yields back. The gentleman from Maryland, Mr. Raskin, is now recognized. Mr. Raskin.
Madam Chair, thank you very much. Delighted to hear my friend from Louisiana speak in strong favor of the Equal Rights Amendment, which I think probably is a good harbinger for our amending the Constitution this century. So it's just a question of exactly when and exactly how. In response to a request for guidance on January 6th last year, the DOJ Office of Legal Counsel, OLC, issued an opinion in response to a request from the National Archives and Records Administration on the ERA. And this OLC opinion concluded the archivist could not publish the ERA because the time limit had passed, and the archivist has stated that this OLC opinion prevents him from certifying and publishing the ERA. So Professor Norris, I want to ask you about the validity of this 2020 OLC opinion from the last administration and the role of the executive branch in the constitutional amending process. First of all, as a general matter, are OLC opinions binding precedent, like a decision of a federal district court or the U.S. Supreme Court?
No, they are not binding.
And are there situations in which OLC opinions are actually withdrawn or modified or reversed? And if so, what are the circumstances under which a prior OLC opinion might be changed or withdrawn?
Well, yes, there's a very famous instance where an OLC opinion appeared to endorse torture, and a subsequent administration withdrew it. In this case, the OLC opinion actually contradicts prior OLC opinions. The Trump opinion contradicts some prior opinions from earlier. So
I got you. So there's nothing unusual at all about changing or reversing a flawed OLC opinion when one administration looks back and finds legally unsound reasoning underlying a prior one, especially when the prior one itself was a reversal of a prior opinion that came to that administration.
That's correct.
Let's come back to the substance then, Professor Norris. In your opinion, is the 2020 OLC opinion legally sound?
No. And why not? Because it is inconsistent with the Supreme Court's decision in Coleman versus Miller. It does not, it purports to bind Congress, to the deadline in a way that's inconsistent with the Supreme Court's opinion, suggesting that this is a political question that the court cannot opine on. And that is my position. I don't think that the court would take this.
If it's inconsistent with prior Supreme Court precedent, is it inconsistent or consistent with President Biden's statements on the ERA?
It is inconsistent with President Biden's statements on the ERA. He has endorsed the ERA. He supports the proposition of sex equality. I've worked with them since 1990 on this. I know that's correct. And so he can, in fact, I'm sure that the Justice Department knows about this. They can, in fact, withdraw this opinion consistent with his policy.
So it seems to me that the OLC should rescind the prior administration opinion, which is what's blocking certification of the ERA today. Can you also clarify the OLC's authority in the case of the ERA? Article 5 of our Constitution gives power to which branches of government over the constitutional amending process?
Well, thank you for that, because OLC really, in this case, really has no authority because the president is not part of the amendment process. We heard from Mr. Conley that the Article 5 starts with Congress. It's about Congress's authority.
Yeah, so it's not only is it not a controlling legal authority in the sense of a court precedent, it's not even really persuasive authority because it's just one person in the last administration in a different branch of government opining as to what the Congress of the United States should do, right?
That's correct. Thank you for, I run a Center on Congressional Studies, and I'm delighted to hear that Congress might be asserting its authority aggressively here. I don't believe that the OLC has authority to determine Congress's rules or proceedings under Article 1, Section 5, or any other provision of the Constitution.
But by the way, do you buy the dogma that we have three co-equal branches of government? I mean, co-equal, first of all, is not even a word. It's like extremely unique or something like that. But the president's role is just to take care that the laws are faithfully executed. The laws passed by the Article 1 branch, the primary and predominant branch of government, as Madison put it. We are the lawmaking branch. We have the power over the amending process, just like we have the power to regulate domestic and interstate commerce. And of course, the court's role is just to adjudicate conflicts over the interpretation of statutes and the Constitution. But would you agree that Congress is really who's driving the train in America?
Absolutely. Hallelujah. Article 1 is Article 1 for a reason. We have forgotten this because we think that the Supreme Court is supreme, and in fact, it was Article 3 for a reason. The court arrogated to itself non-textual authority to reject laws. We're used to that now, and we believe we're a better country for it.
Well, and some people think the judiciary is supreme, and some people think that the president is a king, and so we have to combat both of those dogmas and ideologies. Thank you for your indulgence, Madam Chair. I yield back to you.
The gentleman yields back. The gentleman from South Carolina, Mr. Norman, you are now recognized.
Thank you, Madam Chairman. Let me just emphasize what Chairman Ranking Member Comer mentioned, that we've had 20 requests to have hearings on things that are really a train wreck in this country. Look at our immigration, where people are coming across this border. Women are getting raped, children are getting raped, the drugs coming across. We experience an inflation where everyone is paying 42% higher in gas prices. That is so unfair, particularly for those on fixed incomes. We have an administration that's tone deaf to generals who have criticized the current administration in rank and conspired with foreign countries. We've asked for hearings on things like this because the last 9 months have been an absolute train wreck. But be that as it may, we will continue to ask for hearings that we think are current. Thank each one of our witnesses. I listened for, we have 7, 6 of the 7. Let me just describe what I have listened to. And this is, I'm not going by my script. This is the description that 6 of the 7 have described the country that we live in now. We live in a country where it's equal opportunity for women, as well as equal pay. We live in a country where there's no gender equality. We live in a country that is deeply flawed. We live, I guess the question was asked, why does America hate women? We live in a country where gender-driven injustices exist. We live in a country that Congress has failed us. We live in a country that one of the witnesses says, "I'm afraid of being killed." You wonder why 152 people from 152 countries are trying to get into America, and they're not leaving. I wonder what your testimony would be on the women that are being raped that are coming into this country. I wonder what your testimony would be with the Uyghurs in China who wanted freedom and are now incarcerated. I wonder what your testimony would be with the Kate Stileys that are getting gunned down by illegals. And I wonder what your testimony would be over the 22 cities that have been destroyed, and the businesses that have been destroyed. But this one particularly stood out, Ms. Milano, and thank you for bringing up the Freedom Caucus. I'm a proud member because we promote freedom. But let me quote what you said. Discrimination exists in half of the population of America. Can you name me 3 things good about this country?
Of course I can, but before I do that, I'd like to address a couple of issues, one of which you mentioned rape. I have been sexually abused. I would like the same constitutional equality as my abuser. Second of all,
my time is running out, and I need 3 things good about America that none of the 6 mentioned. Just 3 things that are good about this country.
Freedom of speech.
That's a good thing?
Freedom of choice. Yes.
To kill a child.
I believe that abortion is health care.
Really?
I do.
Should double homicide be eliminated from the books if
I would also like...
Hold on, let me just ask a question, Ms. Milano.
Okay.
I listened to you. If a woman and a child are murdered today and the child dies, it's double homicide. Should that go off the books?
The 14th Amendment creates a constitutional right to abortion. Do you want to repeal the 14th Amendment? I do not.
Name me some more. Which positive? You named the freedom of speech. What's your other 2?
Freedom of speech, freedom of choice.
Freedom of choice.
Opportunity for people that come to this
Thank
country
you for at least
as immigrants. Migration is a real thing, and because of the government's inaction on climate change, it will continue to happen more.
Okay, so those are 3 good things. And then if this is passed, sex could be interpreted. You mentioned you were raped. Sex could be interpreted by the courts to mean a person's sexual orientation or gender identity, implicating faith-based nonprofits, women and children's privacy and safety, and women's sports rights. Is this something you agree with in this? Does this make our children safer by being identified as a man or a woman and going to a woman's bathroom?
So if...
Yes or no? My time is up.
If a state has a compelling interest in maintaining a specific sex-based distinction, for example, limiting a battered woman's shelter to women
You're not answering my question, ma'am.
Them from continued trauma, the ERA will not affect it.
Madam Chair, my time's up. Thank you.
The gentleman's time has expired, and he yields back, but I want to briefly address the claim that, his claim that this committee is not doing enough bread and butter oversight. The truth is that this committee is actively engaged in oversight over waste, fraud, and abuse, especially in the subcommittee on COVID-19, on the contracts that they have let, and on the whole operation, and looking at all of that. And just this week, we sent a bipartisan letter to the IG of the National Archives Records Administration asking for a review of the unacceptable backlog of veterans' records at the National Personnel Records Center. And earlier this month, we had a hearing on FEMA overseeing the administration's response to Hurricane Ida. And in the last 2 months, we've conducted a number of multiple member briefings on Afghanistan, a bipartisan briefing classified with the administration, and we have one set up coming up shortly, and a bipartisan letter to the FBI on the handling of ransomware attacks and the oversight of the treatment of Haitian asylum seekers. And these are just some of the areas that we have worked on it. Just last week, we had an oversight of the Postal Office and Postal Service. And we're coming up with a historic hearing, I believe, oversight of the, it'll be the first time that CEOs of all the major fossil fuel companies, Exxon, Chevron, BP, and others, will be here before our committee. So at this point, may we get back to the
point of order, Madam Chair. Point of order.
We are getting back to recognizing
point of
the
order, Madam
gentlelady.
Chair.
The gentleman's, explain your point of order.
Since you've mentioned me by name, can I have a point of order and ask a question of you?
Sure.
Can we have, and you've named some hearings, but none of which addressed any of the 20 letters that he mentioned. Will you agree now to let us hold at least 1 or 2 hearings on specifics that Chairman Comer has asked for?
We'll take it under consideration.
That means no.
Right. And Mr. Comer, you wish to be recognized?
Yeah, Madam Chair, I just wanted to fact check that about the level of oversight this hearing has provided over the past 9 months. The Lugar Center gave the Oversight Committee an F grade on oversight. So we have a lot of crises in America right now, and I believe we could be doing more in this committee to provide oversight to the American people for exactly what created these crises and how they can be solved.
Okay, thank you. Ms. Bush, you're now recognized for 5 minutes.
Thank you. And let me first start by saying, Ms. Milano, I apologize that you had to endure such cruel, callous, and sexist question line presented by my colleague. St. Louis and I thank you, Madam Chair, for convening this hearing. Equal rights for everyone are still not codified in this country, and it shows. Ratifying the ERA after over a century of struggle will help advance social, economic, and racial justice. It will improve the lived experiences for Black women who are disproportionately affected by inequality and inequity in this country. It is not surprising that the slaveholders, all white men, who wrote the Constitution did not write in equal rights across genders. And it is not surprising that their disregard for gender equity has disproportionately harmed Black women, brown women, indigenous women, and trans women. In my district and in districts across the country, Black women are subjected to harmful policies that make us more likely to be evicted, be underpaid, die during childbirth, lack access to abortion, and be victims of domestic violence, sexual assault, and police brutality. Notice I said and. In 2020, 4 Black women and girls were murdered per day in our country. Racial inequality is a crisis in this country. And it's crucial we recognize and acknowledge the impact the ERA would have on our community. Ms. Jenkins, passing the ERA is a racial justice issue. How would it help women of color, specifically Black women, if the ERA were ratified?
Thank you so much for your question and for your experience and for your bravery and your support of the Equal Rights Amendment. I think what we saw during the pandemic was something that most of us thought was true, but some of us didn't want to face, and some of us still don't want to face, and that is the extraordinary gap in access to absolutely everything that this country says that it gives to its citizens. And we found out who the essential workers were. And we found out what the essential workers were. And we found out that most of the essential workers were Black women, women of color, underpaid, raising families, trying to feed their children, trying to put shelter, give them shelter, and extraordinarily more and more difficult to do so. And so many of them who, in some cases, we see that this discrepancy of the workforce is that women have not been able to go back to work because they're taking care of their children. And in some cases, Black women, women of color, have to go back, even though they have children, because there is no way, to take care of the food and the shelter. So we have this crisis in this country where, as one of the things that I wake up in the morning and I hear this, 250,000 women went missing last year. 100,000 of those were women of color or trans women. Is anybody looking for them? And the answer that we're afraid of is that no, they're not, because women are not valued, and because women of color and black women are not valued. The Equal Rights Amendment is what we need to finally establish, that we are all full citizens of this country, and that we all deserve the rights and the protections and the recourse. And so this is what we believe will do it. The Constitution is the problem. The Constitution has to be fixed. Nothing else will do it.
Thank you, thank you, thank you. Thank you for your comment, your response. It is also not surprising that women of color and queer women of color are leading the fight for gender equity. Today, Black and Indigenous women face higher rates of domestic violence than any other groups. We see achieving gender equality, which you just talked to. We see achieving gender equality as a fundamental piece of achieving justice and ensuring our very survival at a moment when LGBTQ+ community women, the Black community, are under attack like never before. We must advocate for policies that protect our rights and our dignity with the force of law. Ms. Salcedo, I was struck by your written testimony that without the ERA, the Equality Act may lack the constitutional standing to effectively protect trans women and trans women of color. So why do we need the ERA to, in addition to like laws like the Equality Act, to protect trans women of color in our communities?
Thank you so much. The ERA is very clear. I mean, we need a constitutional protection for all peoples. And, you know, the Equality Act, unfortunately, does not do that. The Constitution will do that when the ERA, it's there.
Thank you, and I yield back.
Thank you.
The gentlelady yields back, and the gentleman from Pennsylvania, Mr. Keller, is recognized for 5 minutes. Mr. Keller.
Thank you, Madam Chair, and I'd like to thank all of our witnesses for taking time to be here today. First and foremost, let me state that every American deserves to be treated equally. Putting aside the arguments for or against the Equal Rights Amendment or the ERA, the ratification deadline for this measure ended over 4 decades ago. It seems like we're back in 1979 under the Carter administration, when the ratification deadline for the ERA passed the first time. We were dealing with the same rising gas prices, rising energy prices, rising inflation, and even Americans were being held hostage. If this is the Democrats' version of progress, Americans have clearly stated they want none of it. The ERA failed to be ratified in 1979, then again in 1982, when Congress tried again and failed to extend the ratification period. Americans know the ERA is as unnecessary today as it was 40 years ago. Our citizens are protected under the umbrella of existing laws that shield them from sex discrimination or any kind of discrimination, including the 14th Amendment, the 19th Amendment, the Equal Pay Act of 1963, and the Civil Rights Act of 1964. These provisions already make it illegal for employers to discriminate based on sex. In January of 2020, more women held positions than men in the paid workforce. However, 55% of all jobs lost during the pandemic had been occupied by women. So I have a question, Ms. Stepman. Why are women-held positions disproportionately affected by COVID-19?
I think that's a question you should take up with Randy Weingarten, who's the head of the National Teachers Association. Look, we've heard a lot about European countries in this hearing generally, usually comparing America disfavorably to them. But in most European countries, schools reopened in person just after a matter of weeks, 6, 8, 12 weeks, meaning they opened in summer or fall of 2020. American schools in many states remained closed to in-person learners for far longer, to the extent that even just a couple months ago, many families were dealing with the reality of school closures and having to, what Mary Catherine Ham so delightfully puts it, as she delightfully puts it, Zoom butler their children at school. So I suspect that this is one of the reasons that women disproportionately had to leave the workforce during the pandemic. because as much as many try to fight against it, women still choose to take more of the childcare responsibilities and family responsibilities in the home. And so disproportionately, they decided to leave the workforce when their children couldn't attend school. So again, I suggest you take that up with Randy Weingarten.
Thank you for that answer. Looking at Pew's recent survey of American fathers and mothers, it states that 82% of fathers report that they prefer to work full-time, while only 51% of mothers say the same. What might this tell us about the choices and preferences made by men and women? Any thoughts on that?
Sure, men and women on aggregate have different choices and preferences. This is not discrimination. I reject the idea that because a disparity exists, automatically that means that there is a discrimination at play here. Unfortunately, the ERA, I think, could potentially lead to us taking some of these disparities as discrimination, which would mean that the ERA would be set against the choices of actual American women and about how they want to balance their lives, their careers, and their families. That is not progress for women in my book.
Okay, thank you. And Ms. Stepman, how can lawmakers help support women entering the workforce, whether or staying at home with their children, or a combination of the two?
Well, I mean, I'm sure that's a much larger subject than I can touch in a few seconds. But for starters, just to return to the issue of schools for a moment, it would provide them with better education for their children and educational options for their children. States that provide school choice, for example, in those states during the pandemic, those programs, families were allowed to use those programs to then take their kids to the overwhelming majority of private schools that opened last fall for in-person instruction. But in states where those programs didn't exist, those opportunities didn't exist. And again, as we opened this questioning, those burdens felt disproportionately on mothers, on women.
All right, thank you. And Madam Chair, I do have a letter here from Students for Life that I'd like to submit as part of the record.
Without objection.
Thank you, and I yield back.
The gentleman yields back. The gentlelady from Florida, Ms. Wasserman Schultz, is now recognized.
Thank you, Madam Chair, and thank you so much for holding this incredibly important hearing. I'll just note that I feel quite certain that if white men in this country face the discrimination and inequality that women across the country of all genders and races face, that you would see aggressive advocacy on the other side of the aisle in support of the Equal Rights Amendment for men. And choice of whether and where and when you work is just that. If you did a survey, and if you look at surveys, when women are asked if they think that the Equal Rights Amendment should pass, they overwhelmingly support it. I think that's important to note for the record. And constitutional amendments, Madam Chair, have always served as a signpost for where society needs to go, and the ERA is no different. Beyond clarifying our values, the ERA will have a concrete impact on the most marginalized. There are two major ways that the ERA will impact the legal status of women in all marginalized genders, through litigation and legislation. And first, I want to turn to litigation. Since 2016, there's been a steady rise in the number of federal pregnancy discrimination lawsuits, and the pandemic has only accelerated this disturbing trend. As a mother of 3 children, I was fortunate that I didn't face this kind of workplace discrimination. But I know that compounding layers of economic factors, racism in the workplace, and inaccessibility of paid family and medical leaves make many pregnant women vulnerable to this unlawful treatment. Ms. Smeal, it's good to see you, and a hearty Go Gators, I would say, since we share an alma mater. But is it correct that the ERA could improve litigation outcomes for sex or pregnancy discrimination cases?
Absolutely. There is a Pregnancy Discrimination Act, but it isn't as comprehensive as the Equal Rights Amendment would be. And as we know, there is a lot of pregnancy discrimination in employment.
And certainly increasing. Thank you. And I want to drill down and explore how the ERA could affect a specific legal claim in my home state of Florida. On the first day of Pride Month, the governor of Florida signed a horrendous law banning trans girls from playing on sports teams with other girls. Ms. Salcedo, as a trans woman and advocate for the trans community through your organization, can you explain the impact of this legislation on trans youth?
Thank you so much. I think, this type of legislation obviously denies the opportunities for young people to participate and to just have the ability to engage in sports and the things that people need to participate, particularly young people. It definitely devalues their existence. So this type of legislations continue to really denigrate our community, and it's very damaging.
Thank you. Professor Norse, how might the ERA influence outcomes when judges review laws like this transphobic sports ban, given the decision in Bostock versus Clayton County?
Thank you for asking me that. The Supreme Court decided a case called Bostock recently in which the question was whether Title VII covered transgender and sexual orientation discrimination. And the court said, as a matter of statutory interpretation, that they were covered in Bostock. But that's a statute. It's not the Constitution. And so the court has recognized that the word sex for statutory interpretation includes these categories, but it's not clear that that would actually operate in the same way constitutionally. The court has not actually addressed that. So as far as a state law that discriminated against transgender folks, the Equal Rights Amendment would allow challenges to that law based on the interpretation of the word sex in an opinion by Justice Gorsuch for a majority of this court.
And we cannot afford to let Florida put the transgender community in danger for 1 second longer. It's clear that without the added protections of the ERA, we can't be certain that transphobic laws like this will be repealed by our court system. I want to just get a question in with Senator McClellan, because in addition to litigation, the ERA will enable legislatures to enact and governments to enforce more robust laws that protect women and other vulnerable groups. So, Senator, how would an equality provision in the Constitution give legislators like yourself a new constitutional hook for legislation that protects women and other vulnerable groups?
Thank you for that question, because it gives me an opportunity to address what we've heard over and over about choices that women make that impact the wages that they receive and also whether they stay in the workforce. When you are not allowed sufficient time to recover from childbirth, or when the father is not allowed sufficient paternity leave to care for a child, or to stay home to take care of a child when school is closed, or when you don't have child care, then the ERA gives extra protections to allow state legislatures or Congress to address those through paid family medical leave laws, pregnancy discrimination laws, or similar laws that give women who become mothers actual choices, and not choices that are limited by their employer or a state or a policymaker's view of them as the primary caregiver in that family, even if in that family they choose that it be the father's role.
Madam Chair, I think we made clear why we needed constitutional protection for equality established for women, and I appreciate your decades of support and leadership on this issue. I yield back the balance of my time.
Thank you. The gentlelady yields back. The gentleman from Georgia, Mr. Clyde, is now recognized. Mr. Clyde.
Thank you, Madam Chair. It is becoming increasingly common for this committee to hold sham hearings on legislation that has already passed the House. We did it 3 weeks ago with the Abortion on Demand Until Birth Act, and we're doing it again today. I wonder why this is. Oh, that's right. It's because holding these sham hearings is nothing more than an unapologetic ploy to give the media something to talk about other than the Democratic Party's policy failures and lack of action when it comes to agreeing on how to govern in the best interest of the people. We are facing an inflation crisis, and President Biden and his allies in Congress are carelessly adding fuel to the inflationary fire by advancing their $1.2 trillion, only 9% infrastructure bill and $4.3 trillion big government socialist spending package. Hearings such as the one we are holding right now on ERA are neither productive nor are they applicable to the current issues facing our country. Simply put, they hold as much weight as wearing a politically tailored outfit to a star-studded affair. Over the past year, the so-called Equal Rights Amendment has become both a ridiculous fashion statement and a battle cry for many who fail to recognize the progress the United States has made since the 1970s. But this does not change the fact that the ERA is no longer necessary or applicable. The truth that many of my colleagues have ignored is that men and women are already considered equals under the Constitution. In fact, in many states, women are rightfully offered extra protections, such as sex-segregated hospital rooms, prisons, and shelters, protections the ERA would jeopardize. My first question is for Ms. Stepman. Thank you for being here today, ma'am. I appreciate your testimony.
I'm honored to be here. Thank you.
Would you please share briefly with us how the ERA would affect women's safety and privacy through elimination of sex-segregated facilities?
Sure, I'd be happy to do that. I've already mentioned the effect on women's prisons, where men and women potentially would have to be integrated within prisons and even prison cells when those cells include more than one person. There are many other consequences, though, if we require the law to be completely blind to the fact that sex differences exist. I also mentioned pat-downs in the airport, bathrooms, locker rooms, any kind of facility that any kind of public school, whether that's on the university level or the K-12 level, has separated for boys and girls. Any sports teams connected to those public schools, which we're already having this conversation, but you know, men jump 25% higher, throw 25% further, run 11% faster, accelerate 20% faster. They punch 30 to 162% harder, and they're overall about 30% stronger than females who are pretty much the same size. So this is to similarly sized females. You know, the ERA in Massachusetts, a state-level ERA, has already made a ruling that boys must be admitted to girls' teams. And again, we're no longer just talking about a small percentage of people who are born one sex and identify as another and who may undergo various kinds of treatments to suppress some of the effects of testosterone. Now we're just talking about regular boys, males, who would then be admitted to compete against women. These are opportunities that women and girls cherish and that we have won over time. And I really think that we are downplaying how many times in our everyday lives as women we rely on the law to allow us, for example, for privacy or safety reasons, to separate ourselves from men temporarily.
Absolutely, and I would never want to take that away from women. That would be unjust to do that. As a follow-up, how would this legislation affect life-affirming health care facilities and physicians with religious objections to abortions? Would it have an effect there?
So the ERA's effects on abortion law, there's been quite a debate. There are some proponents who say it does not affect abortion law at all. That hasn't been true in the states. Both New Mexico and Connecticut on state-level ERAs have required under those ERAs that taxpayer funding be applied to abortion. And I'm not specifically familiar with any cases on physician conscience rights, but generally the ERA could provide an alternative basis to continue having a right to abortion in the Constitution. And in fact, most pro-choice groups acknowledge that. For example, NARAL has acknowledged that on their website and has cheered the ERA for that reason.
Okay, thank you. So not only would passage of ERA impose dangerous policies that would strip women of necessary protections, force taxpayer funding of abortion, it would also circumvent the legitimate constitutional amendment process. Differences of opinion and policy aside, the 1972 Equal Rights Amendment deadline expired nearly 4 decades ago. Legislators are attempting to resurrect a dead amendment. Even the late liberal icon, Justice Ruth Bader Ginsburg, noted that the only way the ERA can be added to the Constitution would be to introduce it anew. Even having been a supporter of ERA, Ginsburg recognized there was no path by which you can move forward while simultaneously ignoring the fact that the ratification deadline passed more than 4 decades ago. Even if supporters of this amendment sincerely believe it was still necessary, I imagine they would be willing to follow the guidelines prescribed in the U.S. Constitution, but they're not. Instead, Democrats are choosing to shoehorn through Congress a constitutionally questionable measure. To that end, Madam Chair, I once again implore you to use this committee's limited time and resources to gather expert knowledge on issues that are both current and within the committee's jurisdiction. To do anything else is a shameful waste of our constituents' tax dollars and only allows for more White House policy failures without proper committee oversight. And with that, I yield back, Madam.
The gentleman yields back. The gentlewoman from California, Jackie Spear, is recognized for 5 minutes.
Thank you, Madam Chair. I would also like to remind Mr. Clyde that it was Antonin Scalia who said, when he was asked, does the Constitution require discrimination based on sex? He said no. But he then further said, the Constitution does not prohibit discrimination based on sex, and he implored the legislature to take action to provide that kind of protection and anti-discrimination language in the Constitution. Again, we are one of a handful of countries in the advanced world that do not have this protection for women. I want to thank all the panelists again for their advocacy and their great work. This week marks the 4th year anniversary of the Me Too movement, in addition to being the month in which we observe the tragedy of domestic violence in our country. In 2017, our witness Alyssa Milano tweeted, and I quote, "If all the women who have been sexually harassed or assaulted wrote Me Too as a status, we might give people a sense of the magnitude of the problem," unquote. Since then, the phrase, originally founded in 2006 by activist Tarana Burke, has been shared millions of times all over the world, with the Me Too survivors declared time's up for perpetrators who abuse with impunity. We had members here in Congress who engaged in sexual harassment and who are now being held accountable, and new laws are on the book. All of these people have demanded safety in their workplaces, schools, homes, and in the military. Yet 4 years later, we still face an epidemic of violence against women. Every 2 minutes, another American is sexually assaulted, and more than 3 women are murdered by their partners in the United States every day. Constitutional scholars such as Dean Cherminsky believe that the Equal Rights Amendment will have some of its greatest impact on violence against women. Ms. Norris, can you elaborate on how the Equal Rights Amendment will strengthen the rights of survivors by providing a constitutional anchor for gender equality? And what are some of the examples of the ways the courts have not respected the rights of victims?
Thank you very much for that question. In the United States versus Morrison in 2000, the Supreme Court struck down Congress's bipartisan attempt to give the rights to sexual assault survivors and domestic violence survivors to sue the perpetrators of that abuse. Why? Because the law is unequal. State laws remain unequal. And so what they've done is the court has said, no, this is unconstitutional. So what the Equal Rights Amendment would do, would it provide a way for Congress to reenact laws like this and provide a firm constitutional basis for it? Right now, if Morrison is the law, Congress has no power under either the 14th Amendment, this was an explicit 14th Amendment holding and an explicit Commerce Clause holding. What happens is that under Title VII, your rights, under a number of statutes, your rights end with commerce. Okay, so if you're out of the workplace, if you're a gymnast, if you are, if you were working the gig economy, Title VII is a very limited remedy. And the problem is that the court has said that your rights are fine in employment, but once you get outside of employment, I mean, sexual harassment occurs in all sorts of places in our society. And sexual assault does as well. Look at the members of the military. All they want to do is serve their country. They can't sue anyone for what happened. They get very little protection from the military. We've been trying to deal with that for decades. That's right. So this would allow much greater protection for women because Congress could then enact laws. The Supreme Court says you have no power to. You don't have to believe what Justice Scalia said or what Justice Ginsburg said about the Equal Rights Amendment. All you have to do is look at United States versus Morrison. That's one case. Another case where, in Jessica Lenhardt's case, they said, well, a domestic violence protective order says, oh, you must arrest. Well, Justice Scalia, in another opinion, said, oh, that doesn't really mean you have to arrest. There's always discretion not to arrest, so you have no rights with respect to that. There is impunity by state officials. When I did research in my practicum, I found out that a third of the cases brought under the original VAWA civil rights remedy were state police officers, prison guards, other officials who actually committed sexual assault or harassment of individuals under their care protection. That should be a violation of the 14th Amendment, but why can't you sue them? Qualified immunity. So there's no recourse. ERA would fix that.
Thank you very much, Ms. Norris, and thank you for your legal scholarship as well. My time's expired and I yield back.
Thank you. The gentlelady yields back. Mr. Comer, you're recognized for 5 minutes.
Thank you, Madam Chair. And there have been recent references to Ruth Bader Ginsburg's comments. Madam Chair, I asked for unanimous consent to add to the record Justice Ginsburg's comments suggesting that she believes the 1982 deadline should be considered binding and that she would, quote, like to see a new beginning for ERA ratification.
Without objection.
Thank you. Now, again, want to thank the witnesses for all being here today. Ms. Stepman, would you like to elaborate on the rescissions of the ERA by the states in the past?
I would, thank you. So overwhelmingly, the theory that ERA proponents are advancing, the three-state solution, this modern ratification, I do think contradicts the spirit of Article 5 at the most basic level, right? The reason that we have all of these very difficult procedures, 3/4 of the states, 2/3 of both houses of Congress, is to ensure the overwhelming popularity of whatever we're adding to the highest law of the land. And the theory they're advancing will have no time limits and no rescission. And in fact, you mentioned Justice Ginsburg in those same remarks and in some remarks in 2019, she pointed out the unfairness of that. If you're going to extend the timeline for ratification indefinitely, then it is completely unfair not to allow states to change their minds before the amendment is ultimately passed, ratified, and inscribed in the Constitution. But fundamentally, we haven't really had a conversation about all the consequences that we're talking about today with the ERA because we have had this short-circuited three-state ratification procedure. 62%, as I mentioned in my initial testimony, 62% of our electorate was either not of age to vote or not even born. For example, myself, not even born the last time we had this conversation about the consequences. And indeed, that bipartisan sort of consensus about the ERA and its consequences dissolved exactly because we had a vociferous public debate in which lots of different states and all of our electorate was able to weigh in on those consequences, and American women who make up the majority of voters were able to weigh in on whether or not they want to be treated exactly like men in every single circumstance. Unfortunately, we haven't had the opportunity to have that kind of debate because for most of America still thinks this died in the 70s.
Would you agree, Ms. Stepman, before the COVID-19 pandemic that women were doing pretty well in the United States by several metrics, including low unemployment, wealth, and political power?
That's correct. Before the pandemic, women were not only own the majority of wealth, we get the majority of both undergraduate and graduate degrees. We had the lowest unemployment rate since we started recording female unemployment all the way back in the 1950s in 2019. So to present women as though they are second-class citizens in the United States, I just truly and deeply disagree with that presentation. You know, I'm not a second-class citizen because UVA can have a sorority on campus. That does not, to me, raise the level of second-class citizenship or discrimination. What we're talking about is the law recognizing a small number of instances in which those differences really do matter. And I think that recognizing those differences is very, very important to the freedoms and opportunities and safety that American women rely on.
And that, I agree with that, and that goes along with my point. We, the Republicans on this side of the aisle, we've been very critical of the Democrat shutdowns during COVID, and all the metrics and data that I've looked at show that they adversely affected women more than men. Can you describe how the Democrat-led COVID-19 pandemic shutdowns of businesses and schools have harmed women?
Absolutely. As I mentioned before, I think the single biggest factor in that disparity is likely the fact that schools remain closed long after we knew that we have one big positive thing, right, in this pandemic, this horrible pandemic, which I think is the worst in 100 years. One blessing that we've had is that it largely spares young children. And indeed, other countries have recognized that, which is why most European countries went back to school in May of 2020. So I think that has been the single biggest factor in holding women back during this pandemic, has been the lack of availability of open, in-person public schooling.
Yeah, I agree completely. Thank you, and Madam Chair, I yield back.
The gentleman yields back. The gentlelady, Ms. Presley, is now recognized for 5 minutes. Thank you.
Thank you, Chairwoman Maloney, for today's hearing on the need to ratify the Equal Rights Amendment. Many would have us believe that the ERA has always been a battle led and fought by white women. It's always been a battle, a white woman's battle for white women's gain. But as is so often the case, this is a false narrative. We've seen this throughout history, an effort to erase the women of color who have served as trailblazers, table shakers, and justice seekers in the fight for gender equality. So allow me to bring my ancestors into this room. More than 70 years ago, Black suffragist, civil rights activist, and first president of the National Association of Colored Women, Mary Church Terrell, testified before this House in support of the ERA. In 1970, Pauli Murray, a revolutionary Black queer lawyer and scholar, testified before the Senate Judiciary and reminded legislators that Black women had the most to gain by passing the ERA. She famously said, quote, "I suggest that what the opponents of the amendment fear is not equal rights, but equal power and responsibility," unquote. Senator McClellan, you also mentioned that women of color have the most to gain by achieving constitutional equality. Can you give us some specific examples of what you mean?
Yes, and thank you, because again, it gives me an opportunity to address some misconceptions about why women, and particularly women of color, have been disproportionately impacted by the pandemic. Women of color tend to be dominating professions that are essential workers, because for many years, those were the only opportunities available to those women, and there are generational impacts because of that. Those women did not, in many cases, have access to insurance, health insurance. They did not have access to child care. They did not have the same economic opportunities as their male or white counterparts. And many of them, when they got pregnant, were in jobs where they had to make a choice between immediately returning back to work because they were not given sufficient time off to recover or bond with their child. And in many cases, if their husband was in the picture, they were not granted enough time off to be the primary caregiver. So these are all generational results that go back to slavery and Jim Crow that have not been eliminated with a magic wand just because Jim Crow laws ended. And the ERA will allow Congress and states to pass laws to redress some of that.
Thank you. And certainly we've seen those inequities exacerbated during the pandemic since, again, many of those essential and low-wage jobs are dominated by women of color, frontline jobs who put themselves at risk and could not Zoom into work. I want to turn to a particular right that has been the center of a lot of discussion in Congress and the Supreme Court and in many states throughout the country, and that's the right to safe and legal abortion care. Across the United States, pregnant people of color experience systemic health inequities as a result of centuries of policy violence, including barriers to health insurance, greater stigma, and heightened stress caused by racism. This is certainly true in my district, the Massachusetts 7th, and for many others around the nation. Senator McClellan, can you explain that the role abortion care plays in advancing health and economic equity for historically marginalized communities, and how you've seen that play out for your constituents in Virginia specifically?
Yes, the Supreme Court has long recognized that reproductive freedom is central to one's equality. As the court said in Planned Parenthood versus Casey, the ability of women to participate equally in the economic and social life of the nation has been facilitated by their ability to control their reproductive lives. Abortion is health care, and the ERA is about gender equality in access to health care and the workplace and in school and every aspect of federal and state law and policy. And in particular, Black women have been disproportionately discriminated on the basis of pregnancy, and the ERA would also help with that. And as we have seen states begin to threaten access to abortion, the ERA can help.
That's right. It can help protect our right to bodily autonomy and to advance reproductive freedom, especially for the most vulnerable and marginalized. Professor Norris, at a moment when abortion bans like Texas's SB 8 are threatening pregnant people's right to health care, why are the constitutional protections of the ERA particularly important?
They're particularly important.
Gentlelady's time has expired, but you may answer the question.
They're particularly important because the current court has shown itself to be rather sympathetic to the point that the right to privacy is not in the Constitution, and therefore, without actual text, without a text of the ERA, it may well be that the court reverses Roe versus Wade.
Okay,
thank you.
The gentlelady yields back. The gentlewoman from New Mexico, Mrs. Harrell, is recognized.
Thank you, Madam Chair. Thank you, witnesses. I wanted to follow up with Ms. McClellan on the health care piece on that last question. So how would the Equal Rights Amendment affect longstanding bipartisan restrictions on federal funding for abortion, such as the Hyde Amendment?
Abortion is health care, and the ERA is about whether any laws related to health care or the workplace or anything else would unduly discriminate on the basis of sex, period.
Right. And my point that I want to make is I know we've heard about marginalized vulnerability, but I also think that we have a responsibility to protect those who are the most vulnerable, which are those babies in the womb. And I think when we start talking about abortion, late-term abortion, I think that we're moving away from really our moral compass and what our responsibilities are. And then we start ignoring who the true vulnerable are. But thank you for that. I want to ask Ms. Stepman a question. To me, it feels like we have a solution in search of a problem. How would passing such a bill hamper, especially young women trying to go into college? How would this hamper their opportunities when you look around at college applications and now looking at transgender athletes and et cetera? Would there be a problem with that, in your opinion?
Yes, I actually think the ERA creates a much bigger problem than the accommodations for transgender athletes, as disruptive as those have been to the opportunities for women and girls. For example, Chelsea Mitchell in Canton High School of Connecticut, she's lost 4 state championships to all New England awards and other honors to a male-bodied athlete. But Chelsea wrote in USA Today, "That's a devastating experience. It tells me that I'm not good enough, that my body isn't good enough, and that no matter how hard I work, I'm unlikely to succeed because I am a woman." The ERA would even have a broader effect, right? Because again, we're talking all of this societal debate that we're having about how to accommodate, for example, transgender athletes, is ultimately about a very small percentage of the population. The ERA places a ban on discriminations, quote unquote, on the basis of sex of all types. So it's not just a male-bodied athlete who identifies as female that girls will be competing against, but a male-bodied athlete who identifies as a boy. So when that girl that you mentioned goes off to college, perhaps she's comes from a small high school where she has been competing on the track team, and she gets a scholarship to a university to continue, a public university to continue running track. The boy who missed the cutoff for the boys' team with his 100-meter dash can edge her out just on the basis of that score, because the only reason that that boy is kept off of that team is because he is a boy. That is a discrimination on the basis of sex and is forbidden by the plain language of the ERA.
Right. So, in my opinion, I feel like I think what we're doing is now we're weaponizing. Now we're using the same gender protection against those who would already be protected under this. I mean, when we're going to now see discrimination because of a gender situation, or we're going to be awarding those that are biologically men or boys over those that are women, then I think what we're doing is we're really essentially trading places. And I fear that what we'll be able to do, or what we'll see happen, is we will use the courts then anytime we think that there's something running afoul, that we will actually squelch the voices or silence those who then I think would be hurt by this. And I just want to follow up that same question to Ms. Salcido. I mean, would you find that there is discrimination if someone is born a boy or a girl and then being treated differently in a transgender environment? Isn't that discrimination against, say, a young lady who's trying to get a college a degree, but utilizing her athletic ability to get a scholarship and can't get in because the scholarship's been awarded to somebody who is obviously going to be faster or stronger in a certain athletic event? Does that make sense to you? Aren't we just reversing the discrimination, if you will?
What I can tell you is really about my own personal experience, and I also want to say that it is really unfortunate that we use examples that are not necessarily real, right? The lives of young trans and gender nonconforming people are real lives. And when we use rhetoric that diminishes them, it's basically we're telling them that we're not valuing them. And
I don't think that's true, though, and I apologize if it sounded that way, because I think every human life has value, and I don't think it's rhetoric to say that. I don't think it's right to say it's rhetoric, because it's certainly not rhetoric. I mean, I've read in the papers where people, men identifying as women, have gone into matches, say wrestling matches, and actually injured, in fact, cracked the skull of a woman because of the strength differential. So it's not all rhetoric, because I think everybody has value regardless of what their gender is and regardless of what they identify as. I'm sorry if you want to continue. We're just about out of time.
Do you want me to answer what you just?
Sure.
So, you know, I think that, you know, when I say rhetoric, it's really there's no research that proves that that young people are different, right? Because young people, you know, their bodies don't stop developing until they're 25. And so when we use lies that, you know, young people and children specifically are different, they are not necessarily different.
Right.
They're both the same.
Right. Thank you for that. And really, thank you all for being here today. And Madam Chair, my time's expired.
The gentlelady, the gentlewoman from the District of Columbia, Ms. Norton, you are now recognized for 5 minutes.
Thank you, Madam Chair, for this important hearing. 50 years ago this very month, the House of Representatives passed the Equal Rights Amendment with overwhelming bipartisan support. As a former chair of the Equal Employment Opportunity Commission, I can tell you that even though the momentum behind the ERA waned after the first major push passed, the need for it never has. If the Constitution is silent on women's rights, other than the right to vote, we find, and it took us some time to get that right, we find ourselves fighting the same fights for equality over and over again, fighting hard just not to lose the rights we already have. Professor Norst, let me begin with you. How does the ERA help make sure that gender equality is not dependent upon the political leanings of the Supreme Court justices, and how would it affect the standard by which gender discrimination cases are considered by the Supreme Court?
Well, thank you, and I say hello to a former member of the faculty of Georgetown Law. Thank you for that question. I believe the Equal Rights Amendment would, in fact, support a stronger standard of review with respect to legislation that is passed which denies equality, as well as allow more legislation by Congress which supports equality. But I want to clarify this because there's a lot of conversation here about sex differences being banned. No sororities, sports teams, you know. That's not what this is about. It does not say, the amendment does not say or require enforced equality in sort of precise way. It doesn't ban same-sex schools. That requires you to think that strict scrutiny, which is a legal term associated with the highest of rights, which is likely to be invoked under the amendment, is actually fatal in fact, and that is not good law. We've shown in the race discrimination affirmative action cases, as you know, Ms. Norton, that strict scrutiny is not necessarily fatal to legislation. So if there were a compelling reason for a particular kind of sex difference, that could still be sustained under the Equal Rights Amendment, in my opinion.
Well, that's a very important answer to get, and I certainly appreciate it. Ms. Smeel, gender discrimination has persisted for over the last 50 years. The harms from discrimination have long-term effects on individuals and entrenched inequality that has consequences for the nation as well. Ms. Smeel, you were around for the first go-round of the ERA fight in Congress. Many people attribute the failure to ratify then to prominent women who fought against it. What do you think was the real reason the ERA wasn't ratified then? Who was behind the opposition? And what motivated them to oppose equality for women?
Mike, please.
Oh, thank you. Women were blamed. Shafley was given credit, but the reality is we had far more. We had every major women's organization on our side. We had thousands, in one demonstration alone, 400,000 telegrams were sent in to urge passing of the extension. I believe, and we did so many events. They would have a few hundred people, we'd have a few thousand, and the press would try to balance it out. Who was really behind it was the Chambers of Commerce, National Association of Manufacturers, and the insurance companies were big lobbyists against us.
Why were they against it?
Well, the insurance companies even put in an ad out saying, Aetna did, our case for sex discrimination. At that time, health insurance, auto insurance, annuities, pension plans, I could go on, all discriminated on the basis of sex. And if you look at it overall, we had a whole NOW project on insurance discrimination. Just in auto insurance alone, although some argued that men paid more, if you had it based on miles driven, women were paying far more. If you looked at health insurance, it was very discriminatory. As I said before, frequently did not cover pregnancy and usually charged women between 150 and 200% more for the same coverage. If you looked at pension plans, women were charged more because supposedly they live longer, but we could show that difference wasn't as much as people had in their mind. In other words, they were taken advantage of in there too. I could go on, but basically, that was always kept as a woman's fight, like it was a cat fight, when there was a lot of vested interest in keeping women in a certain position. We talk about essential workers all the time, but they were forced to work at minimum wage because, in fact, there weren't that many opportunities for women. There was mass discrimination against them. And I also felt that we had terrible problems from some universities. The University of Florida, I'll just give you an example. I was an alumni, my master's degree is from there. It was a very progressive part of the state, but the senator from there was always against it. And why was he against it? Because he thought the Gators would lose money because obviously in most universities it's a disproportionate amount of money is put on male sports versus female sports. So there's all...
The gentlelady's time is expired, and wrap up.
Thank you.
Okay. We now recognize the gentleman from Georgia, Mr. Johnson. You're now recognized for 5 minutes.
Thank you, Madam Chair, and thank you for your work, your tireless effort in promoting and bringing about the opportunity for this Equal Rights Amendment to become law. And also thank you, my dear colleague, Eleanor Holmes Norton, for all that you've done in that regard. And I want to thank the witnesses for their testimony today. When the U.S. Constitution was drafted to protect the rights of, quote, we the people, end quote, at that time, people meant white men, and it did not mean women at all. 140 years later, and with the passage of the 19th Amendment, women gained the right to vote. However, this essential milestone has proven insufficient to bring equal opportunity to women across America. To this day, despite making up more than half of our population, women still earn less of what men earn for the same job, and this disparity is even worse for women of color. It's past time to ratify the Equal Rights Amendment, which would guarantee equal rights for women under the Constitution, and I'm a proud supporter and co-sponsor of H.J. Res. 17, which will remove the arbitrary deadline of 1972 for ratification of the Equal Rights Amendment. Now that 38 states have passed the amendment, all that remains is for Congress to approve this bipartisan legislation. Ms. Milano, The Guardian reports that the wage gap between actors and actresses in the film industry is significantly greater than most other industries. Men make about $1.1 million more per film than their similarly experienced female co-stars. What kind of sense can you make of that gross pay disparity that exists within the film industry? And what does it say about equal rights for men and women in your industry?
Thank you, Congressman, for your question. For every dollar a man makes, the average woman makes 82 cents, with Black women earning 62 cents to the dollar, Native women earning 57 cents, and Latinas earning 54 cents to the dollar. This is not different in my industry. And I would also like to add that we've heard a lot from our Republican friends that about our economy and about women getting back to work. Women are not, we don't have the choices to be equal parts in our economy. And it has been researched that if we were equal partners in our economy, it would boost our economy $4.3 trillion over the next 10 years, as per the ERA Coalition's research. So what are we hoping for? In my industry, but mostly for the most vulnerable women, we are looking for equal pay for equal work, prevention of discrimination in hiring, firing, promotion, and benefits, protecting women from pregnancy discrimination, and it would provide a constitutional basis for claims of gender violence. The modern woman needs the ERA to provide protections against the rolling back the advances in women's rights that have already been achieved. And when we talk about women having choices, I just want to say that most of the time, we are not given choices. There are certain jobs that we can do as women, or we are allowed to do as women, most in hospitality or domestic work or frontline workers. So I really resent the notion that women are making different choices. We have different opportunities, and part of that is because of having no constitutional equality. We are just looking for equal protections, equal opportunity, equal rights. And if we are treated as anything less than human, we also ask for equal recourse. Thank you.
Thank you. Ms. Norris, the 7-year ratification period is not a constitutional requirement for the passage of the Equal Rights Amendment. Would you agree?
That's correct.
And so why are we hanging our hats on that? Why is it that that folks are using that arbitrary ratification deadline as a means to deny formal adoption of the Equal Rights Amendment?
The gentleman's time has expired, but you may answer the question.
I believe that the fight against the ERA has always been about distraction. So when it was first fought in the 20s, it was about labor, then it was about gay rights. We got to find something. No one's really against equality for women. It's 94% of people approve it. So people get distracted by things that are not important to the legal questions here. Congress has the authority to extend the deadline if necessary.
Thank you, and I yield back.
Thank you. The gentleman from Vermont, Mr. Welsh, is recognized for 5 minutes.
Thank you very much. I really appreciate the testimony of all the witnesses, and much has been said, and I can't, even with my questions, add too much. But I'll just ask if any of the witnesses, I think this will be almost probably the final words. Professor Norris, is there anything that we've left out? Anything that you can say to folks who are resistant to the passage of the Equal Rights Amendment that you'd like to say?
Well, thank you for that. I'll just repeat what I said. Don't get distracted by slippery slope arguments. Really bad things are going to happen. I mean, they've been saying that about the Equal Rights Amendment for a very, very long time, maybe 100 years. These are speculation. So I would hope we would fix our focus on what we do know, and what we do know is that the Supreme Court has not allowed Congress to enact legislation to protect pregnancy discrimination. We have legislation, but they have not said that pregnancy discrimination is actually constitutionally barred. They have not allowed for Congress to pass legislation with respect to gender violence. And it's an important constitutional insurance policy given the current court, which will, in fact, in my view, because of its jurisprudential philosophy, turn many protections that women have, at least they will, I would think they would restrict them in ways that most people would not appreciate.
They're really at risk. I agree with that. Thanks. And Ms. Jenkins, can you speak to the way, this current patchwork of state and federal laws fails to protect women's rights and guarantee equality under the law?
As has been said by my sister panelists as well, what the Equal Rights Amendment will do, and what we desperately need, is fundamental constitutional underpinning of the rights of women and girls. For every, listening recently to the discussion about the Violence Against Women Act and the opposition to that and the delay in the reauthorization of it, we cannot, by piecemeal, give fundamental equality. It doesn't work. Every season gives us another chance to detract from full citizenship and from full life-saving rights. So we really, I think, in this country need to come to grips with the fact that the Constitution does not fully support girls and women. We need to do that. Let's get the Equal Rights Amendment. Some people have said, well, it's just a symbol. I say, yeah, like, the flag. All right, give it to us. We need that symbol as well as the legal rights that go with it. We need young girls to feel that they belong here. We need women to not be engaged in this constant quest for equality and for rights. There's a recent rally in the streets, and I said, it was a big crowd, and I said, I'm so glad to see you all here, but let's not keep doing this. Let's pass, it's, of course, pass the Equal Rights Amendment, but let's get two things that we need. The DOJ memo lifted, and in the Senate, the time limit removal bill. Let's do those two things and move on. A full century is enough time to have women in a begging position. We're tired of that. We want our rights, and now is the time to do it. It's the best time that we have to do this now. Thank you for the question.
Well, thank you very much for your advocacy and your eloquence. I can't add any more to that, Madam Chair, so I yield back, and I thank our panelists for their wonderful presentations.
Thank you. The gentleman yields back. The gentleman from Maryland, Mr. Sarbanes, is recognized.
Thanks very much, Madam Chair. I too don't expect to speak for the entire 5 minutes. I mostly wanted to thank the panelists that you've assembled today for their very compelling testimony on behalf of the Equal Rights Amendment. I want to thank you, Madam Chair, for your tireless, unending efforts to make progress on this. And we've had some real success in the House of Representatives recently because of your efforts, because of the leadership of Congresswoman Spear and so many others of our colleagues. So I just want to be another person on the committee and among your colleagues to put that recognition and gratitude on the record. We know that this is bipartisan. It's been bipartisan from the beginning, the effort to get the Equal Rights Amendment passed. Anytime there's a robust effort to lift it up, you see that bipartisan commitment. And we know as well that, the other side, the opponents to this will sort of say, well, why do we need this? There's no real imperative here. Our society has moved to a place where this is just sort of a window dressing exercise. But we know from the testimony today that there are real and critical legal protections that come when we finally get the Equal Rights Amendment certified. And those provide protections to people in our country who can benefit tremendously from them. So that's very real. But one of the panelists a moment ago talked about the symbolism here. And as much as it will be a powerful symbol if we can ultimately and hopefully soon certify the Equal Rights Amendment of what America stands for and our principles, our not being able to get it done is also a powerful symbol. It says that there's still something that resides in the body politic, in the kind of fabric of our nation that keeps us from being able to make this important statement about who we are. So the failure to do this, the inability to do this, the not doing it is also symbolic in a negative way. And I think we want to overcome that, send a very powerful, positive message about America's commitment and principles, and also as well put in place and facilitate and fortify key legal protections that can flow from this. So again, thank you for your leadership, Madam Chair. Count me as you always have among
I want to ask
strong
my colleague before you yield back.
and I yield back.
Please don't yield back, because I want you to yield to some of your time to Ms. Milano, who has some things she wants to say.
Okay, let me do that.
Okay.
Ms. Milano, please, I'd love to hear your thoughts.
Thank you. So we've heard a lot today about women not needing the ERA because of the 14th Amendment. But I want everyone to note that that came 5 amendments after, or before, sorry, the 19th Amendment, which is our ability to vote. So clearly the 14th Amendment does not provide equal protection, or women would have had, been allowed to vote after the 14th Amendment was passed. Also, I want to say we've also heard a lot today about just starting over. Let's start this process over. How long do we need to wait for women, trans women, non-binary people to be included in our founding document? Thank you very much.
Thank you so much. And
Thank you very much, Ms. Milano. The time is now, absolutely. Let's get this done. Chairman Maloney, thank you for all your terrific work and for convening this hearing today.
Well, thank you, and I'm so appreciative to all the like-minded men that are trying to help us with this ratification. Thank you. Before we close, I want to offer the ranking member, Comer, an opportunity to offer any closing remarks he may have. You are now recognized.
Well, thank you, Madam Chair. And again, I want to thank the witnesses for being here. And Ms. Milano, I'm a fan of your movies. Appreciate you being here. We all support equal rights, and we're very fortunate to have the Constitution that we have, which guarantees equal rights. And I know that we've talked a lot on our side about unintended consequences of the Equal Rights Amendment, and it's important when we have political debate that we debate the pros and the cons of legislation, because a lot of times what happens is, especially with my friends on the Democrat side, they get caught up in the political correctness moment, and they don't anticipate unintended consequences. For example, you can talk about climate change and the need to address climate change, and you can pass legislation and have policy and mandates like the Biden administration has done that has the unintended consequence of gas prices going up more than 100% in less than 10 months. You can print money by the Treasury to help provide guaranteed income and extended unemployment and things like that, but the unintended consequence is inflation, which is a tax increase on everyone. You can declare a border wall is politically incorrect. The unintended consequence of that is, of course, open borders. When you have open borders, obviously the unintended consequence of that is you have an increase in drug smuggling and human trafficking. You can defund the police as a reaction to a bad cop or several bad policemen, which is a micro minority of the true actions of our overwhelmingly tremendous male and female police force. But when you defund the police, you have the unintended consequence of increased crime. Again, you can pay people not to work, and you can do things like mandate vaccines, but the unintended consequence of that is labor shortages and, of course, supply chain disruptions. So we are blessed to live in the United States, the greatest country in the world. I know that several people referenced other countries that may have more preferred language in their constitution about equal rights. I didn't hear anyone say anything about Afghanistan, which this administration just turned over a lot of our military weaponry and our very nice military base, Air Force base too. So we've come a long way in the United States. We have more work to do, but I appreciate the opportunity to be able to have a conversation about this issue. And Madam Chair, I yield back the balance of my time and look forward to having more hearings on government oversight and reform. Thank you.
Well, thank you. The gentleman yields back. And I would like to really thank all of our witnesses today for sharing their expertise and their experience. And I appreciate that we managed to come to some bipartisan consensus that all men and women should be equally treated in this country. A number of our friends on the other side of the aisle made that statement. And the ERA is the way to achieve that. Legislative measures alone are not enough and are too easily rolled back. From my own experience, I have spent more time fighting to hold on to what we have than moving forward. And if we could have those guarantees, then the efforts of men and women that care about equality of treatment could be spent in other ways. I was just thinking that we have 50 years after the passage of the Equal Rights Amendment, and we heard from many of our panelists today that it is more important today than ever. And I couldn't help but think, how would our country be different if we had, in fact, ratified the Equal Rights Amendment in 1972? Victims of sexual violence would have the right to sue under the Constitution. And possibly the amount of sexual violence and assaults would have fallen in our country so that Alyssa Milano would not have had to start the Me Too movement that she started and worked with Tawana and others so brilliantly. Salcido, who talked so movingly about your own personal journey. I think it's very difficult for people to share troubling times like that, but certainly people from marginalized genders would certainly likely be covered by the ERA and would have more protections. And certainly the assault that we have now in Texas is almost unbelievable to me. They're absolutely rolling back. They've already rolled back under their draconian law, the right to abortion, really. Most women don't even know if they're pregnant at 6 weeks. And that I think it would have empowered women enough not to have had that happen, and is happening right now. And Carol, you spoke so beautifully about wanting to empower women, but particularly women of color, and certainly this would have given them more protections. We know that economists tell us that the number one area of poverty in America is older women, because the unfair treatment in their pay translates into lower pensions, lower Social Security, lower retirement, if they have any at all. And certainly there would be less women in poverty in America. And equal pay for equal work, it hasn't budged the gap in 30 years. And if you had equality in the Constitution, then you would be able to enforce equal pay for equal work. It's that simple. It would give the right to women to enforce. So if I had one question, I would ask the panelists to write for Congress how you think. You're all specialists in this, and you've devoted your lives in it. How would America be different if the Equal Rights Amendment had been ratified? I know my life would have been extremely different, and I believe most women's lives, and I want to really thank not only the panelists, but the like-minded men in our country that have been our allies, that have worked side by side with us to try to reach ratification. And we've waited too long, so we're not giving up now. And I'll continue working with all of you to ratify and get women and protections into the Constitution for full equality. And I yield back. In closing, I want to thank all of our panelists for their remarks, and I want to commend my colleagues for participating in this very important conversation. And with that and without objection, all members have 5 legislative days within which to submit extraneous materials and to submit additional written questions for the witnesses to the chair, which will be forwarded to the witnesses for their response. I ask our witnesses to please respond as promptly as you are able. This hearing is adjourned.